Hello everybody. Hello. Yes, we're back. We are back. I'm still getting organized here, so just 1 minute. Okay, hello. Yes, hello. Oh, I'm still getting myself sorted out. My goodness. Okay, that's just fine. Yeah, come back whenever it works for you. So, absolutely. 6 o'clock. I will always be 6 o'clock on TikTok. Just sometimes on YouTube, I may go at a different time other than 6. So, but yep, I'm always at 6 on TikTok. Yes. Oh, yes. I'm trying to get everything sorted out. Hello. Tara, good to see you. Coffee Cat, good to see you too. Wonderful. All right. Yes. Hello. Oh, no, love only. No, I was just clarifying for you. Nope, I've got, with the level of aggression I didn't get any aggression from you whatsoever. So no worries. Yes, I am married for a very, very long time. Very long time, happily. So yes. Let me just continuing here to get everything pulled up. Oh my gosh, I'm so far behind today. It's been a busy day. It's just been very busy. Yes, we do a pretty deep dive into a lot of things. So, oh, how am I feeling? I am feeling very good. I'm feeling much better. So, yes, hello. Hi, April. Good to see you. Snappy Squid, always a pleasure. Yes. Oh my goodness. Yes. Hello, Gen Xer. Good to see you. Yes, there's been a lot going on today. It's been busy. Yes, so these are my murder nails because we're going to be going through the Murdaugh case tonight. So, yes, these are my my murder nails. Thank you. Oh, thank you so much. Yes, special treat as we go through a double homicide case. So I thought it was appropriate. But oh, hello, Kristen. Good to see you. So I'll just wait a few minutes here for everyone to join as we get going. But I've got a lot of fun information to go through. Yes, this is one of my favorites for sure. Hello, Chuckleberry. Good to see you. Yes, Sarah. Yes, it is. It is. That word seems to be okay, but do you believe this really happened? I think they have some interesting points. I will be really interested to see how things turn out. So, very interesting affidavits that have been put into place. And they were pretty thorough, so we'll be able to go through a lot of the information. Hello, Deborah. Hello. I double checked all the moderators to make sure everything is working, so you all should be good to go now. Yes. Well, Roberta, what I saw was that the ACLU has, in Georgia specifically, has come out with a statement expressing their frustration with it. So I think that that's really good. I'm glad to see that. I think a lot of people are involved now, so I'm excited about that. Oh, thank you so much. I appreciate that. I always want to call you Tay because of the accent at the E there, but welcome. I'm so glad to see you always. Why did the clerk write that book? Oh my gosh, I tell ya, she got herself into some trouble. She really did. So, Yeah, she's in some trouble. She's in some deep water for sure. Some very, oh, it's Ellie. Okay. Well, thank you for sharing that with me. Yeah, every time I see it, I'm just like, is it Tay? Is it, or is it the? I just want to make sure. Clerks. Oh my gosh. Oh, you got it, Tiffany. Oh, some of the clerks that I've worked with in the past, like I wasn't surprised at all when I saw the information coming out. I really wasn't. We'll take a look at it tonight for sure, but I wasn't particularly. Oh, well, that's so sweet. Yes, this is the clerk for the Murdaugh case. So we'll be going through that tonight. Before I dive too far in, well, they're asking for a stay. They've already appealed, so they're asking for a stay, and then there's a motion for a new trial. So we'll be going through that. But I did want to state, I did notice the clerk of court wrote a book. Has anyone seen the... I know this just came out right before I came online that there was a motion for the DC judge to recuse herself. Oh, thank you, Diva. I appreciate that. I just want to make sure that if anyone who's interested in that had knew about that. Yeah, had known. And, you know, it seems like it's making a really big splash. Yeah, the recusal. So I thought I would, you know, kind of just give an overall overview of what my thoughts are on that. And if you're interested in that, real quick as we get started. Yes, so the clerk of court who was in charge of the Murdaugh situation, the clerk of court, she had written the book. Yeah, actually, Diva, I'll go through that book. The title and several pages are quoted in here. So yeah, the JC case. So just as a real quick for everyone who's interested, let me just show you just real quick. We had, and I'm just going to give you my 2 piece about it, my 2 pence or my two cents. We're not in Britain about it, but there was a recusal request put in for Judge Chutkin in DC. And yeah, I think we'll be okay. But I would, before we get too worried about it, I just want to say, let me just show you something here. I had to go digging, but here is a motion for recusal for the judge in the New York case, which was denied. And we have a motion for recusal and a motion to quash for DA Fani and the judge in Georgia. And then don't get me even started on the situation with Letitia out of New York. Miss James, she's been filed against repeatedly. So it seems like every jurisdiction where there is a case going, with the exception of Florida, they've all been filed for motions for recusal, the judges along with the DAs. So yep, it's just part of the protocol that he does. So I'm not concerned about it whatsoever. Yes, recusal means he's claiming that the judge is biased, and he's asking her to remove herself from the case. And he does that in every case. So yeah, that's just exactly PS4. You got it. That's exactly what he does in every case. So you know, I was digging through my paperwork, and there were, 6 different motions for recusal all over the place. And actually, the number of motions he's filed against Miss James out of New York is really astronomical. He's actually filed lawsuits against her to prevent her civil case. So, yes, Meadows' appeal is pending, last I heard. So yeah, it's a stall tactic. Absolutely, absolutely. It's just part of it. Hello, Vicky. Welcome, welcome. You never asked Judge Cannon. Yeah, that's a good point, isn't it? That's the one case I couldn't find a motion for a recusal. Doing the best they can with what they have. Absolutely. That is absolutely true. So what does a motion to suspend appeal for leave of file mean? So sure. Yeah, let's just kind of start tiptoeing into the business here. We had a conviction, right? Mr. Murdaugh was convicted of homicide. And so they appealed that, and they've got on file an appeal. Now, with the new information that we'll go through here, which sets out some different exhibits and some different pieces of evidence that they gathered, they're claiming there's enough evidence here for a new trial. So they're asking for a pause to be put on their motion for appeal so that they can go forward with this motion for a new trial. So they're wanting an evidentiary hearing to be set so they can talk about whether or not the problems that existed with this clerk of court and the jury rise to a level of getting a new trial. So yes, these are my homicide nails. Yeah, I thought it was appropriate. Yes, now the FBI has been notified, and they have been asked to come in and take a look at everything that's been going on. So it's quite the to-do. It's quite the big deal. It's fascinating. Judge Newman, yeah, I thought so. I thought Judge Newman did a pretty good job. So, and there are some questions involving him as well in this. So, did the appeal work? Oh, you'll have to be more specific. The appeal in this case hasn't been decided yet. So, the appeal is on file, and they're asking it to be paused. Been so sick, haven't been watching the lives. Oh, no, Jay. Oh, I hope you're feeling better. Yeah, bring the jury. There are multiple affidavits in here that we can go through, which have some interesting information. I would really like to get everyone's perspective on what they think, if the evidence is good or if it's not that great. So, for sure. Oh, thank you, Vicki. Oh, yes. Sorry about that. I did win the appeal. Yeah, there were some problems, but I think we'll be all right. Hi, CJ. Welcome. Yeah, I'm just, jury's yeah, interesting. I'm not convinced he did it. I mean, he claimed he didn't too. So there's a lot of pieces in there. There's going to be a lot of interesting pieces. So, all right. Do different judges affect a jury trial that much? Oh, absolutely. So the judge's decisions on motions and objections during a trial make all the difference. And of course, the most classic example, I'm getting the name of the book for you here. Here you go. So here's the book. But when they decide things on objections, the best example, of course, would be the O.J. Simpson homicide case, and Judge Ito, and his decisions were the ones that really decided that case, which you can see from the evidence in the civil trial, the difference between the different kinds of objections, although the level of proof is different, but still, the way that the court deals with the objections and pretrial motions and those kinds of things is very important. So there you go. Esquire and attorney versus lawyer. They pretty much all mean the same thing. It just depends on where you're at. And, we just kind of call each other different things depending on your jurisdiction. Like locally here, an attorney means you're licensed, but a lawyer could also mean a trial lawyer. So, it really depends. Esquire typically just means you've got your JD, but you're not necessarily licensed. So, yes. Oh, thank you, Oren. Thank you for saying that. Yes, we've got some good questions. So let's go ahead and dive in. If everyone's ready, let me just make sure. Am I centered okay here for everyone? Just want to make sure before I get going. I am in the central time zone. I was not convinced OJ did it. Well, he certainly says he didn't. So yes, okay, I am. Thank you. Tanita, appreciate that. A little bit to the right. Oh, there we go. I have these different tape markings, but it seems like my camera angles can sometimes be messed up. Yes, April, I'm back. Okay, how is that? Is it better in frame? Have I moved enough to the right, everybody? More? Okay, yes, thank you. Yeah, this is my double homicide. Okay, a little bit more to the right. Okay. Boy, once I get set, I'm going to have to retape and make sure. All right, there we go. Am I in a good spot? Okay, thank you. I'm going to be very, very careful here to make sure I stay in frame tonight because it just drives me bonkers when I watch the playback and I get out of frame. It's one of my biggest pet peeves, so I'm going to try really hard. I always post my lives up on my YouTube channel or my Tube of You channel within about 24 to 48 hours. So I do have to keep my posts on the Tube of You to maximum of one a day. So depending on what I've got in the queue will kind of be dependent on that too. So I will have this posted. So here we go. Oh, good, good. No, I'm afraid not. Real life works. Not tonight. We're going to go through Murdaugh tonight, but I do tomorrow. I will be going through the special grand jury report, but I will be doing that on my Tube of You channel. I will be going up at 6 o'clock Central. Oh, thank you. Thank you so much. So if you do want to jump in and join more of a discussion about that, it will be on my Tube of You tomorrow. So listening to your, oh, yes. Oh, sister, that's a tough one. That was a tough one. That was a tough night for everybody, I think. Oh, no, real life. It's fine. No, it's absolutely fine. Actually, so tonight we'll go through Murdaugh, and then on Thursday here on TikTok, I will be going through Project 2025. So I will be going through that. It'll be, we're going to really crack it open. Like my Torts professor would say, we're going to crack it open like a tauntaun in Star Wars and look at it. So... Yes, it's posted. It's linked, Rebecca. I've got it linked in my bio. Oh, yeah, absolutely. Absolutely. So Tuesday on my Tube of You channel, we will be doing the special findings. And then Wednesday on my Tube of You, I will be going through the Colorado petition. And I think that's really important. I will be really doing a deep dive into the 14th Amendment. So hello, Suze. Hello. Yes. Yeah, Mary, it's not great, but I think it's very, it's nothing new. It's not anything that's shocking. It's just something that's definitely circulating now more in the media is the one thing I've noticed. So, absolutely. We will be going through that though. So I've got 2 nights on YouTube or my Tube of You, and then Thursday I'll be back for 2024. Nope, we're getting there, Empathy. I hear ya. It is frightening, Frank. I don't think there's getting around that at all. It is absolutely frightening. All right, here we go. So what we've got Mr. Murdaugh, who was convicted of double homicide. Now, he had appealed his case after the jury found him guilty, and what has happened was his attorneys were made aware of some information that had been given to the jurors. And so they had this question, was the clerk improperly influencing the jurors? And if so, it could be grounds for a new trial. So they have filed this petition. This was filed on September 5th. And he set out a whole bunch of affidavits from different jurors that were on the case, along with Facebook posts and different excerpts from the clerk of court's book that she self-published after the verdict was out. So why not a dismissal? Because they want to leave the appeal in the queue in case their motion for a new trial is denied. So they're asking for this to go first, but they don't want to dismiss anything at this point. Yes, we got to kind of ignore the troll. Brittany, I've got some questions. I certainly do. So let's go ahead and dive on in, and we'll kind of look at the different pieces of evidence. I like to really take everybody through evidence. I've been in so many criminal trials that I think it's really important to take a look at the different standards here. So, appellant Richard Alexander Murdaugh, pursuant to Rule 29B of South Carolina Rules of Criminal Procedure, hereby moves for leave to file a motion for a new trial based on after discovered evidence. So any kind of evidence that comes to light after a verdict has been given, you always would come back and file a motion for a new trial. And to suspend the appeal during the pendency of the motion. Again, that's just putting that on pause in order for them to assess the situation with a new trial. Here's a copy of the motion for a new trial, attached Exhibit 1, and Also, we've got exhibits A through L. Now, his filing here, this motion just gives kind of an overview, but I have printed out the exhibits of each of the affidavits for the jurors, and along with actually some transcript pieces as well. This will go pretty fast. Each exhibit is only a couple of pages long, so we will go through that. Oh, thank you, Roy. Yep, I'm back. No, there's no question about rules of evidence, and I'm glad you asked that, because typically when we do a motion for a new trial, we can say, hey, there were some significant problems, clerical problems, or bad rulings on motions. But in this case, what they have said is they have found new evidence showing that there was interference with a jury, and that's a huge, huge no-no. So that is absolutely not allowable. So, as the memorandum in support of this motion and documents supporting facts relied upon, not contained on the record on appeal. So again, the record's bundled up and sent up to appeal. So they've included new things. So as required by Rule 240 of the Rules of Appellate Procedure. So this is kind of that introductory piece. Everyone has signed it and it has been filed. So again, this is just kind of an overview of these exhibits. So this will just be kind of an introduction, and then we will go through each of the exhibits. How is this different from double jeopardy? Sure. So what would happen here is if a motion for a new trial is granted, it means that the verdict is overturned. The verdict is tossed out, and that means we don't have a final answer. And if we don't have a final answer on a particular criminal case, then you can't have double jeopardy again. Great question. So let's take a look at it. Let's get into it here. So we've got a motion for a new trial. Defendant Murdaugh, through undersigned counsel, pursuant to rules of South Carolina Rules of Criminal Procedure, moves the court for a new trial after discovering that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by the defense. So what they're going to try to do for a motion for a new trial, we have a different burden that we have to prove. We have to show that there was a fundamental flaw or something that was so harmful that it created this process of not being able to have a fair trial. So it has to be subject matter is key, and that it was so dramatic, the amount of new evidence, that it allows for a new trial based off of it. So testimony and other evidence presented by the defense. Now, this, again, if we keep in mind, too, Mr. Murdaugh had testified on his own behalf, so this is pretty significant. Pressuring them to reach a quick guilty verdict and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror she believed to be favorable to the defense. Now that, of course, would be completely unacceptable if it's true. Keep in mind, again, this is a defense motion. We're only hearing one side of the story. Specifically, during trial, the Colleton County Clerk of Court, Rebecca Hill, instructed jurors not to be misled by evidence presented in Mr. Murdaugh's defense. She told jurors not to be fooled by Mr. Murdaugh's testimony in his own defense. Again, this is the key, that he testified in his own defense. Ms. Hill had frequent private conversations with the jury foreperson, which is absolutely not allowed. A court-appointed substitution for the foreperson the jury selected or elected for itself at the request of Ms. Hill, which, as clerk of court, I'm not sure she's supposed to be making those requests. During the trial, Ms. Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. Now, if this is true, that also is a huge no-no. That is not allowed. Ms. Hill invented a story about a Facebook post to remove a juror she believed might vote not guilty. Or might not vote guilty. Ms. Hill pressured the jurors to reach a quick verdict, telling them from the outset of their deliberations that it shouldn't take them long. Again, this is a direct quote. That kind of language would be incredibly prejudicial. Ms. Hill did these things to secure for herself a book deal and media appearance that would not happen in the event of a mistrial. So now they're setting out what the motive is here on why she made the comments that she made. Ms. Hill betrayed her oath of office for money and fame. And of course, we're all sworn in if we're going to work for the government. Once these facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial, which is correct. So here's our statement of facts. Mr. Murdaugh was indicted for the murder of his wife, Maggie, and son, Paul, on July 14th of 2022. His trial began January 23rd of 2023. The presiding judge was the Honorable Clifton Newman. The trial ran for 6 weeks, ending with convictions on the evening of March 2nd of 2023 and sentencing on March 3rd. The state rested its case in chief and the defense began its case on Friday, February 17th. Court was not held on February 20th, which was President's Day. After returning from the holiday, Ms. Hill began to enter the jury rooms often. Now, what I've done here, because they're just giving this overview of all of the exhibits, is that I have highlighted where exactly they're talking about. So again, I will be going through each one of these exhibits. This is just the overview. So anything highlighted here are from statements and exhibits that they're submitting along with this. So, as the defense began its case, Ms. Hill told juries, quote, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." Additionally, Ms. Hill and juror number 826, the new jury foreperson, on multiple occasions went to another room to have private conversations lasting 5 or 10 minutes. Sometimes they would go into the jury's room, single occupancy bathroom together. Foreperson juror number 826 never said anything about the content of those conversations to other jurors. Ms. Hill even instructed jurors that they could not ask foreperson juror number 826 about their conversations. Now, this, of course, would not be allowable at all if this is true, which, of course, we don't know, but it's, being put out here. 2 days later, on Thursday, February 23rd, and continuing through the next day, Mr. Murdaugh testified in his own defense. Before he began his testimony, Ms. Hill told jurors not to be fooled by the evidence Mr. Murdaugh's attorneys presented, which led one juror understood to mean that Mr. Murdaugh would lie when he testified. Now, this piece here, the credibility of a witness, especially when the witness is the defendant, that's huge. That would absolutely, if true, that would be grounds for a new trial right there. Ms. Hill also instructed the jury to watch him closely, to look at his actions and to look at his movements, which at least one juror understood to mean Mr. Murdaugh was guilty. Immediately after Mr. Murdaugh testified, foreperson juror number 826 told the jury that Mr. Murdaugh was crying on cue. She also criticized the former foreperson, juror number 589, for handling Mr. Murdaugh a box of tissues when he was crying on the stand, because that is what the defense wants us to do. This is all awful if this is true. The next court day after... let me make sure I'm in frame again. Sorry, everybody. The next court day after Mr. Murdaugh's testimony, Monday, February 27th, Ms. Hill told Judge Newman about a Facebook posting she purportedly saw on the evening of Friday, February 24th, the day Mr. Murdaugh's testimony concluded. While pursuing a Facebook group page called Walter Burrow Word of Mouth, here's our citation here in Exhibit C, which we will go over here once we're done. The post, purportedly by juror number 785's ex-husband, Tim Stone, allegedly stated that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be. Judge Newman asked her to produce a copy of the posting. She could not produce a copy, but according to Ms. Hill, a subordinate employee of the clerk's office, Lori Weiss, discovered that the post was taken down and replaced with an apology post. So this is the apology post they were able to get. They did not get the original post. This is the quote here. "Folks, I posted an ugly post yesterday to which I have deleted, and I kind of, in a roundabout way, directed it towards a certain person, and I would like to apologize to everyone who read it that ugly for me to do that. Yes, I let Satan control me, and I broke down and started drinking. And when I was this, I made that post, and I'm sorry. Rebecca Hill, quote, Behind the Doors of Justice. So they're citing her book in order to get this information. So anytime this is a citation, we're going to have an excerpt from the book that the clerk of court wrote. Also, we have another exhibit. So exhibits D and E have this quote in it. The apology post states the initial post was already deleted on February 16th. So it would have been impossible for Miss Hill to see the original post on February 24th. Mr. Stone, Juror 785's ex-husband, avers in a sworn statement that he made no such post. August 18th of 2024, his affidavit, which is Exhibit F, Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity from January 23rd to March 2nd, which confirms he did not post the apology. The supposed original post, if deleted, would not be recoverable at this point under Facebook's retention policies, and that he, in fact, never posted anything to the Walterboro Word of Mouth Facebook page during the trial. And this will be backed up with Exhibit G. The person who made the apology post is an unrelated person also named Tim Stone. Ooh, we have a second Tim Stone. The plot thickens. Whose Facebook profile picture is not juror number 785's ex-husband. On February 28th, Miss Hill questioned juror number 785 about the fictitious post on Walterboro Word of Mouth alone in her office in the courthouse. That's Exhibit H. She told juror number 785 that someone had emailed her stating her ex-husband, Tim Stone, posted on this Facebook page that juror number 785 had been doing this with her ex-husband, and that while this, she expressed opinions on the guilt or innocence of Mr. Murdaugh. Juror number 785 told Miss Hill that never happened and that she had not seen her ex-husband in 10 years. Juror number 785 asked to see the post, but Miss Hill would not show it to her. Miss Hill directly asked juror number 785 whether she was inclined to vote guilty or not guilty, and that is absolutely not allowable. That is not allowable if that is true. Juror number 785 said she had not made up her mind. Oh, yes. Later that day, Miss Hill told juror number 785 that SLED and Colton County Sheriff's Office personnel went to Mr. Stone's house and he confirmed he made the post. This is a fabrication by Miss Hill. So we've got a full-blown lie situation. Miss Hill told juror number 785 she would somehow reinstate a restraining order juror number 785 previously had against Mr. Stone, which is something that Miss Hill did not have the authority to do. It's true, as clerk of court, she would not have that authority, but as clerk of court, she does work with restraining orders, so there could have been some kind of inferred understanding there, which is completely illegal. Still later that day, Judge Newman examined juror number 785 regarding both the non-existent Facebook post and the tenant coworker email in camera, which means in chambers. So let's bump down here. A coworker of tenant of juror number 785 emailed the court on February 27th, stating that the tenant said her landlord was a juror and had expressed an opinion when delivering a refrigerator to the property more than a week earlier. Oh my goodness. All right, back up we go. So we have this discussion then between the judge, who knew now about this Facebook post situation, and the juror. Juror number 785 described her interactions with Miss Hill regarding the post. She denied making any inappropriate comments about the case to third parties and stated she wanted to hear closing arguments before forming an opinion on Mr. Murdaugh's guilt or innocence, which would be appropriate. After she was dismissed, Judge Newman said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me." That's not a good quote from the judge. Oh dear. Oh dear. Oh dear. He was right to be concerned. The next day, on March 1st, this statement right here would make the judge a witness for the hearing for a new trial. This just pulled him in as a witness. Yeah. Yep. It's not saying that he's done anything wrong. It's just saying he would be called in as a witness to testify. All right, the next day on March 1st, the jury visited Moselle, the site of the murders. During the visit, four-person juror number 826 and Miss Hill walked off to have yet another private conversation. In her book, Miss Hill more vaguely hints at communicating her opinion on Mr. Murdaugh's guilt to the jury during the visit to the property, which of course vaguely hints. That's, that could just be something that people are perceiving if, she's saying that. That would be something that would be questionable. So while the jurors viewed the Moselle property, we all could hear and see Alex's story was impossible. Okay. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. All right. At that moment, many of us standing there they knew that Alex was guilty. So it looks like that was really important information. That day, Judge Newman also held in-camera conference regarding the tenant-coworker email in which he decided to revisit the Facebook post issue with Miss Hill. Again, in camera just means in chambers. The court, okay, well, let me see what Becky's talking about. I wanted to revisit the post that you mentioned yesterday. Miss Hill, right. The court, that's Becky Hill, the clerk of court. Can you tell us about the Facebook post? Miss Hill, yes, I think it was Friday evening. Just for a brief moment, I pursued the book face, got on Walterboro word of mouth, and saw where someone had said that, well, it was the ex-husband of a juror. And he said he noticed that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be, and that he was the ex-husband, but she was known for talking way too much. And then I kept on scrolling because that was enough for me. I've gotten enough. The court. And how do you determine who he was talking about? Well, I heard there was an email on Monday. I figured the two went together if it was true. Well, she confirmed she has an ex-husband who she has had 3 restraining orders out against. So, right. So then we looked on Monday after you told me to try to go back and look for it, and we couldn't find it. But then we found out his name, and we found the post and printed it out where he said he had put something up, but that he had deleted it at the time, and he had put some stuff out there that wasn't nice. And he said he got drunk afterwards. Something about the devil. Don't he say it was Satan in it? Didn't he say it was Satan in it? Oh my gosh. Satan was in it, yes. And all the details, yes. All right. Made me do it. Okay, I just wanted to have that on the record. You're reading the Facebook post by the ex-husband who said it. Of course, you haven't talked with him, so you don't know where he got his information from. I don't. I can find it, though. Oh, my goodness, that was difficult. Sorry. Yeah, the devil's always in the details, isn't it? All right, so that's a direct transcript from the court reporter. Yeah, the devil. Yeah, misspelled Satan. All right. But Miss Hill never saw any such Facebook post. She made it up. Further, she knew the apology post was not posted by Juror 785's ex-husband. Juror 785 showed Miss Hill a picture of her ex-husband. Let me pull this down again. Sorry about that. If I'm out. There we go. Back in. There we go. Which is not the Facebook profile picture of the other Mr. Stone's post about Satan. Now we have posts about Satan. Let's just make a note here. Satan post. The next day, March 2nd, 2023, the day of the verdict, juror number 785 received a call from her ex-husband that she did not answer. The call upset her because Miss Hill's lies had led her to believe he was posting on Facebook about her and might be stalking her. Juror number 785 asked to speak with Miss Hill. She told Miss Hill she was scared. Miss Hill told her that the Murdaughs probably got to him, meaning her ex-husband. Miss Hill once again asked her opinion regarding Mr. Murdaugh's guilt. Again, this would be absolutely inappropriate. Juror number 785 told her that Creighton Waters' closing was good, but that she still had questions. Miss Hill asked what questions, and juror number 785 replied that she was concerned that no murder weapon was found. Miss Hill then asked, well, what makes you think he's guilty? Juror number 785 said Paul's video at the dog kennels. Miss Hill then told juror number 785 that everything Mr. Murdaugh has said has been lies, and that I should forget about the guns. They will never be seen again. Wow, that's a lot of direct quotes here. That's very disturbing. Miss Hill then asked juror number 785 about the views of the rest of the jury, telling her that if the foreperson would just go in and ask for a raise of hands, this would be over and done with, and everybody needs to be on the same page. Now, this would also be some influencing issues here. Yes, it's because of the clerk of court. Exactly, Rack, you got it. Juror number 785 went to the jury room and 10 minutes later was excused from the jury. In open court, immediately after her excusal, jury number 785 asked Judge Newman if he had spoken with the clerk of court, referring to the conversation earlier that morning with Miss Hill. Video of trial proceedings, March 2nd of 2023, available at this site. Judge Newman responded that, quote, I have not spoken with her today, and that this is totally independent of any conversation regarding her ex-husband, apparently misunderstanding her question to refer to the issue of the post. When the jury began deliberations that evening, Miss Hill told them this shouldn't take us long, and that if they deliberated past 11 p.m., they would be taken directly to a hotel, even though none were prepared to stay overnight. This is hinky right here. I'll just let you know that. When it comes to our criminal juries, we do everything that we possibly can to make them as comfortable as possible. So if there was some kind of question about having to go to a hotel or anything like that, as the attorneys on the case and the judge, we would have taken care of all of those things beforehand. Yeah, all of this would have been taken care of. We would never put the jury in a situation where they had to stress about something like this. Our job is to remove the stresses from all of our jurors and make sure that they're comfortable in order to do their job. So this is hinky right here. Additionally, smokers on the jury asked to be allowed to take smoke breaks as they had previously been allowed to do during the 6-week trial. But Miss Hill told them they could not smoke until deliberations were complete. This is also hinky. We want to make sure our jurors are as comfortable as possible. And if that means they need to get up and walk around or have a 15-minute break, get something to eat, get a drink of water, or just take a break because things have gotten too intense, we always accommodate that for our jurors. This is very unusual to ask to put this in and say you're not allowed to do this. And I'm not even sure the clerk of court would have that level of authority either. So that's a little suspicious. Meaning, if she actually did that, her behavior is suspicious. And that kind of request is suspicious also. The hinky southern, yes, it's a little bit. Yeah, Lisa, I agree. Yeah, we are so careful with our jurors. Like if we're, especially a 6-week double homicide trial, oh my gosh, and just from what I saw from the judge, this judge is going to want to accommodate them as best as he can. So this is kind of unusual, I think. There were 6 smokers on the jury. So, I mean, that's like half, right? I'm not good at math, but I can figure that out. Nail color tonight. Murdaugh, I know, this is my double homicide manicure for the night. The clerk of court, right. So the clerk of court is usually chosen. It's a process you go through like any other employment where the district court makes the decision, they review applications, and then they hire the clerk of court. The clerk of court is in charge of running the dockets, of hiring assistants and other people to make sure that the process, the proceedings go smoothly. So kind of like the judge's scheduler to some degree, but also making sure documents are filed properly and so on. So that's really what the clerk does. Different from the court reporter who takes down word for word what's happening during trial. So was she elected? Yeah, I'm not sure, Emily. Typically, our clerk of courts are chosen by our courts. So I could be wrong. I don't know that much about this particular jurisdiction in South Carolina. So that'd be great if you, if anyone knows if she was elected or not. But Miss Hill told jurors after the trial they would be famous and predicted that the media would request interviews with them. Miss Hill even handed out reporters' business cards to jurors during the trial. Ugh. Juror number 578 took this to heart and made an appearance on Good Morning America the night of the verdict. Whoa. Oh, she was elected. Okay. Okay. Do we double check that? Well, that's interesting. I'm wondering how she was elected. If it was a local race then, like with the county auditor and the county treasurer, and so the clerk of court, just is very unusual to me. That's why I can't quite wrap my head around it. So, but I'm, if that's how it was, the county clerk of court, first term elected official. Okay. Ooh, well, I don't think she's going to be able to get reelected. Okay. Clerk is elected in Pennsylvania. Very common in the South. Really, Megan? Really? Even in Texas? Wow. Very interesting. Okay. Good to know. I heard the clerk of court's daughter performed in court while recessed to entertain who was there. Oh my goodness. Let's say the judge agrees all this happened. What would happen to Miss Hill? Well, I mean, she's still acting pretty independently. Unusual. Yeah. Elected in 2020. Okay. Oh, thank you so much for looking that up. It is unusual. It's an unusual practice. It sounds like it's something kind of known to be done there in the South, which is, that's kind of questionable, really. I think they're elected in Ohio. Really? Okay. The county clerk there too. All right. Good to know. I had just not heard of that. I must be, I am not in the South. I am not that far south. Can she be charged? Potentially. Yeah, absolutely. In South Carolina courts, sure. I know she was a court reporter for years. Okay, well that makes sense, Lisa. That makes sense. Yeah, it's unusual. County clerk elected in Virginia. Interesting. Yes, it was Hill that wrote the book. Okay. Being elected, she would be impeached or removed from the position. Absolutely could be. As an elected position, we in the South are different. Yeah, I'm not really... Small town. Yeah, this is definitely a small town. Local clerks run for election, but not higher court clerks. Okay, Andy, that's good. That's good to know. Wow, I'm learning so much. Hinky, yes, I agree. Like, who pays attention to who the clerk of court is? I mean, people don't even vote for judges. Like, who's going to do that? We're talking about the clerk of court here. Small counties in Missouri also elect their county clerks. That's fascinating. That's so interesting. Everybody in that area knows the Murdaugh. Well, yes. Elections in Indiana. Okay. Oh, boop, boop, Greg. Missouri votes for judges. Yeah. And it's pretty common to vote for judges, or like retention and those kinds of things. But a clerk of court, I did not know about that. It's probably a popularity contest. I would imagine so. If it's a county election, when you have those county auditor or, county supervisor, all of those positions are all really kind of popularity contests. We don't do it in New York. Yeah, I know. That's different. Don't some jurisdictions elect dog catchers? I don't know. I'm my whole world's been blown right now. I'm just like, my mind is like, pshoosh. Yep, vote for judges. Yeah, we do that here too. She got a book deal before it was a deal. Yeah, that's the real question. Yes, absolutely. Has info for the state. Yes, it's interesting. We also vote for judges. Yeah, we split on that. We definitely split, depending on where you're at. So she won 4-3. Interesting. Okay. All right. Well, let's dive back in here. She knew Murdaugh from his trials. She'll move when yeah, there's going to be a lot of issues going on. All right, so we've got juror number 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during trial. Whoa, we've got a Perry Mason moment there. Someone's wearing a suit coat. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a network news show. She traveled with jurors to New York City and appeared on the Today Show. She got her book deal. Her book, Behind the Doors of Justice, was released on August 1st of 2023. At last, I'm so glad, Perry, always good to see you. At last point about Miss Hill's efforts to promote her book shows her dishonest efforts to profit from the trial continued. Well, after the verdict, a film crew negotiated a contract with the Colton County Sheriff's Department to use courthouse bailiffs to provide security while they filmed a documentary. Now that's another thing, is we don't have a lot of bailiffs left in our counties, in my area. So they filmed a documentary at the courthouse when it was closed for Confederate Memorial Day. I'm sorry, I need a moment. Did you say there's a Confederate Memorial Day? Is this the first time I have ever heard of a Confederate Memorial Day? What? South Carolina has that? Oh my gosh. Wow. I'm learning so much. Tonight. Virginia has one? What is going on? You can tell I am not from the South. Oh, yeah. All right. So, wow. Okay. You don't have that in Tennessee. Yeah, I had no idea. Does Texas too? Really? I had no idea. We didn't celebrate that in my family when we lived in Texas. My goodness. Wow. Okay, I'm just pausing for a moment. I'm learning so much. Okay, not North Carolina. Oh my gosh. All right. So they closed the courthouse. All right, here we go. Let's dive back in. So many learning moments here. So, during the Confederate Memorial Day, apparently, the film crew had previously recorded an interview with Miss Hill. On May 9th, Miss Hill sent a memorandum to the film crew purporting to be an addendum to the contract. We've got that Exhibit K, which I will be going through here in just a few minutes. In it, she demanded that the film crew pay Colton County a fee of $1,000 per day for use of the courthouse facilities, and made a nonsensical statement about not having authority outside South Carolina that reflects a failure to understand the choice of law clause in the contract. Whoa. Then she bizarrely added a handwritten demand. So this is her demand added on. Also, in exchange for the use of the likeness of Rebecca Hill in an interview, a minimum of unclear 5-second video and audio clips will accompany the usage on the first reference. The book cover for the photos. She's trying to plug her book into the documentary. Oh no! Behind the Doors of Justice, the Murdaugh murders will be shown, and audio will include Becky's introduction as clerk of court for Colton County and author of the book. Whoa! Oh my goodness. Wow, that is bold. That's like bold. Yeah, I'm still struggling with the Confederate Memorial Day. I'm still struggling a little bit. I really truly had no idea, and I have learned a lot about this country. I didn't know about that. All right, the film crew ignored her addendum as the contract had already been executed. Well, good for them. But like her jury tampering during trial, oh no, it was an attempt to violate South Carolina Code, which provides no public official, public member, or public employee may knowingly use his office, membership, or employment to obtain an economic interest for himself. So this is really important. Some would say this is a little bit, reminds me a little bit of the Hatch Act, just a little bit, just a pinch. All right, let's get into the legal standards. So, do we have grounds for a new trial? Let's see what their standards are in South Carolina, which is a whole new world. A whole new world of law here. A defendant in a criminal prosecution is constitutionally guaranteed a fair trial by an impartial jury, and in order to fully safeguard this protection, it's required the jury render its verdict free from outside influence. We're citing State v. Johnson here. When the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury, the defendant has entitlement to an evidentiary hearing. Again, citing more case law. This court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. And we are bumping down to a citation here. Looks like we've got a 3-part test. So this is what they're going to be looking at in order to determine whether or not a new trial is appropriate. The trial court is directed to consider whether, 1, the contract was made in an effort to influence the juror by or on behalf of a party in whose favor the verdict was rendered, or 2, the contact was such as would obviously influence the juror, or 3, the trial judge finds the contact either influenced or probably influenced by the jury. So it looks like either of these, any of these could work, not all, but any. Really, in North Carolina, Lisa, my goodness, what's going on over there? I think sometimes we forget about some of our other states if we don't spend a lot of time there. If the defendant proves the alleged contacts occurred, the prosecution bears the burden to show they were harmless. Oh, the llama. Oh, we love the llama. Thank you so much. In a criminal case, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, if not made in pursuance of known rules of the court and the instructions and directions of the court made during the trial with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice to and hearing of the defendant, that such contact with the juror was harmless to the defendant. So the key standard will be, was it a harmless contact? This is the standard that has to be determined. And it looks like, according to case law here, that they're citing that burden of that harmless contact is on the state then, not on the defendants. Yeah. How could you take the job and not know that? I agree. Yeah, I'm pretty, there's a few places I certainly do not visit, as is clear by my lack of knowledge of those areas. The presumption is even stronger where the contact was made by a court official, where, quote, there was the private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless. So again, we've got this issue of what was the subject, what was the content, and was the content in the content in the contact harmless and could not have affected the verdict. Now here's the argument. We'll get into this as well. A state official, I just saw a comment here, change of venue. So, Lisa, that's such a good point because, and I'll just point here so I don't forget where I'm at. But if they were to grant a new trial in this situation, right, they would have to pull in a brand new jury. And so we've been talking so much, how can we have an impartial jury? I'm not sure I could imagine in this venue how they could find a jury that had not been familiar with the trial that had already occurred. It would be a huge issue when you have a trial that's already happened versus, the first time we're going in for a trial. So, well, yeah, everyone knows the case, but I think the jury pool, though, is even smaller because they've already had a 6-week trial, which, it was already covered by all the news. It was all over the place. Everyone's talking about it. So, again, when we have that first trial, yeah, they're going to be able to find some people, but a second trial, I don't know. They may need to move it. They may have a legitimate venue issue. All right, here's the argument. The state official, Rebecca Hill, the elected clerk of court, had extensive private communications with members of the jury during trial. This allegation is supported by sworn affidavits of jurors and a witness to juror interviews, testimony at in-camera proceedings, meaning in chambers, and other evidence, including Miss Hill's own book. That's really bad when you write a book that incriminates you. That's not good. That's not a good idea to do that. The court therefore must hold a Remmer evidentiary hearing. If the allegations are proven at the evidentiary hearing, then under binding appellate precedent, the court must grant a new trial unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. Again, this harmless error situation, harmless contact. The subject matter of Miss Hill's communications was the evidence being presented at trial by the defense. These improper comments and efforts to influence the juror's verdict vitiated the sanctity of the jury's deliberation and Murdaugh's sacrosanct right to a fair and impartial jury. Boy, we've got some big words in here for no reason whatsoever. The court, therefore, must grant a new trial if the allegations are proven. In a 6-week trial, people will talk when they should not. They will say things they should not say. Mistakes will be made. The participants in a trial are fallible human beings. Lawyers combing the proceedings after the fact will always find they made mistakes and errors. If that were enough to force a redo of the trial, no verdict would stand. The trials would be repeated forever. That's a really good point. To avoid that, courts properly strain to find that mistakes made during trial are harmless, meaning they did not change the result. So that's the ultimate piece as well. Lisa, I saw that as well. I think there's a mandatory retirement age for judges, which I think is not a bad idea. I think it's a very good idea. But the issues now before the court are not the ordinary and inevitable mistakes that occur in any trial. The issue here is that an elected state official engaged in intentional misconduct, deliberately violating a defendant's constitutional right to a fair trial before an impartial jury. Oh, thank you, Lisa. To secure financial gain for herself. I mean, that's tricky. I mean, she did publish the book where a state actor engages in private communication with the jury about the merits of the prosecution. The verdict is impossible to sustain. For example, in Parker v. Gladden, a bailiff told a juror in a murder trial that wicked fellow, he's guilty. The Supreme Court of Oregon held the statement did not require a new trial because it was not shown the statement prejudiced the outcome of the trial. The U.S. Supreme Court reversed, holding the evidence developed against a defendant shall come from the witness stand in a public courtroom where there is full judicial protection of the defendant's right of confrontation, of cross-examination, and of counsel. And we have followed that undeviating rule that the rights of confrontation and cross-examination are among the most fundamental requirements of a constitutionally fair trial. In this case, the court has declared on record that the verdict that the jury reached is supported by the evidence, circumstantial evidence, direct evidence, and all other evidence pointed to only one conclusion, that's the conclusion you all, the jury, reach. And we're citing a video here. The court has therefore foreshadowed the outcome of any harmless error analysis. But the rule for deciding whether to grant a new trial is not whether the court believes the outcome of the trial would have been the same had Miss Hill's jury tampering not occurred. If that were the case, the court would sustain a guilty verdict, even if she coerced the jury to vote guilty at this. Boy, these words are just tossed around freely here. Because in the court's opinion, all of the evidence pointed to only one conclusion, the guilt of the accused. If the strength of the evidence against the accused in the eyes of the court excuses deliberate jury tampering by a state actor, the result is a directed verdict for the prosecution, a structural error. This cannot be the law. And then we're quoting the Nieder case, and Scalia is concurring, noting that if the judge certainly reached the right result, a directed verdict against the defendant would be per se reversible, no matter how overwhelming the unfavorable evidence. Because the very premise of structural error review is that even convictions reflecting the right result are reversed for the sake of protecting a basic right. Yeah, I agree. Difficult word choice here. Instead, the law requires the subject matter of the communication to be harmless, clearly harmless. Asking the jury what it wants for lunch is clearly harmless. Telling it not to believe the defendant when he testifies is not. Now, that's a good point. That's a pretty good point there. Our Supreme Court recently made this point in State v. Green. Notice how recently is 2020, just everyone. So you know, in the legal world, this is recently. This is like yesterday. In Green, during jury deliberations, a juror asked a bailiff what would happen in the event of a deadlock, and he responded the judge would likely give them an Allen charge and ask if they would stay later. The Court of Appeals held the bailiff's comments were presumptively prejudicial because of his official position, but that the state rebutted the presumption by showing for various reasons that the remark did not in fact influence the outcome of the jury's deliberations. The Supreme Court affirmed but modified the decision to correct the Court of Appeals' reasoning. The communication was not presumptively prejudicial because the subject matter of the communication was harmless. The bailiff's action here, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. In other words, a bailiff telling the jury that if it's deadlocked, the judge will instruct them to keep deliberating is improper, but likely harmless, because the subject matter is procedural or logistical, rather than to be the merits of the case. Telling the jury not to believe the defendant's defense or his testimony when he testifies regards the merits of the case. Ms. Hill's extensive, deliberate, and self-interested jury tampering far exceeds the simple bailiff mistakes that forced a retrial in Cameron, where a bailiff's misleading response to a juror's question about sentencing options compromised the jury's impartiality, because it left the impression that their verdict could not affect the trial court's sentencing discretion. Or in Blake, where a bailiff told a jury that the trial judge did not like a hung jury, and that a hung jury places an extra burden on taxpayers. Oh, that's not nice. Don't say that. Unlike the honest mistakes of the bailiffs in those cases, Ms. Hill had many private conversations with jurors about the merits of the case. She asked jurors about their opinions about Mr. Murdaugh's guilt or innocence. She instructed them not to believe the evidence presented in Mr. Murdaugh's defense, including his own testimony. She lied to the judge to remove a juror she believed might not vote guilty, and she pressured jurors to reach a guilty verdict quickly so she could profit from it. Each of these actions violated Miss Hill's oath of office, her responsibility to the citizenry, oh my gosh, everybody, I can't say it, okay? Citizenry and the judiciary of the state, and Mr. Murdaugh's constitutional right to a fair and impartial jury. The law applied to these facts requires a new trial. Conclusion: for the foregoing reasons, Mr. Murdaugh respectfully submits the court must hold an evidentiary hearing. We got it. Thank you, Ava. Appreciate it. Okay, when those facts are proven, the court must grant a new trial. All right, so respectfully submitted. So there we go. So there's the motion. There's the motion for a stay of the appeal. Sorry about that. Let me get my sound in check here. So we have a motion to suspend the appeal from the guilty verdict in order to go forward with a new trial. That's not a real word. Yeah, I'm wondering. I don't know. Oh, we'll see. Number 6 on Amazon. Really? Oh dear. Yes. Oh dear. All right, let's go through the exhibits. Again, these are really quick. Each exhibit is only a couple of pages, and I think it will give us a better idea of what kind of evidence we're looking at. So if their summation is appropriate or if they've kind of overstated the situation. So would they call in the jurors to testify? Yes, they would, Jordy. That's exactly what they would do. Why would Miss Hill not have a book if he was found innocent? That's a great question, Suze. That's an excellent question. She absolutely would have. I'm not sure that that's their strongest argument. For sure. Yes. That's much different than the prior examples. I agree. It is a bit different. Citizens of a place regarded collectively. Thank you, Law H. Appreciate that. Citizenry. So thankful. I am learning so much tonight, everybody. This is my night of learning. How quickly is this request like this reviewed? So this was filed on September 5th. So just a few days ago. I mean, it's been 6 days, but you got to take out the weekend. So I would say any day now we would know whether or not a hearing would be set. So any time it should happen. Is there cameras to show the clerk going to the bathroom with the foreman? I think that they've got some video, but I don't think they've got that. I don't think the defense attorneys going door to door to jurors was a good look. Oh, Megan, that's a really good point. Yeah, so the three attorneys that put together this motion had gone door to door asking jurors about it. Some jurors, which many of them wrote out affidavits that we'll go through, but some jurors were like, we don't want to talk about it. And, it could be they just don't want to talk about it, but it could also be, it's a small town and they kind of made their decision on what they wanted to do regarding the situation. Whenever we get into a small town dynamics with a trial of this caliber, these kinds of things can really come into play. It can definitely be an issue. One of the jurisdictions that I practiced in many, many years ago, actually right out of law school, was a very small community. Everybody knew everybody. Everybody knew who was asking questions and so on. So, oh, V, thank you. Yeah, super sparkly. Super sparkly for tonight. All right, let's take a look at these exhibits here. We've got a good old boys. Absolutely, Megan. Absolutely. Very influential family in a small town. Yes. Grew up in a village. Oh, okay. Hope the profits from the book were worth prison. Oh my gosh, that's the question, isn't it? Gotta run. Oh, well, thanks for coming by, Michelle. Always good to see you. Take care. Have a great night. Yes, I try not to tell too many of them, but yes, yikes. All right, so let's take a look. We've got juror number 630. Let's go through what they've written out. Now, keep in mind with affidavits, there's been a lot of talk about affidavits a lot lately, but did the clerk help pick the foreman because the jury wanted to vote to pick one? It seems like the clerk had some kind of an influence. I'm not sure exactly, but I think we'll get into it here in a little bit. Going to go to bed. Yes. You still can't block, only mute. Okay, Deborah. Oh my gosh, I'm glad you told me. I'll take a look at it again. I thought I had gotten you set, but thanks for coming by, Deborah. I really appreciate it. Let me just make a note here so I remember to check on that. Have a fantastic night. Appreciate you being here always. All right, so here we go. Juror number 630. Affidavits are just sworn statements that are given. So they're basically saying, I swear that this is the truth. But when it comes down to it, I mean, again, it's like you're giving your word. So it could be contempt of court if you're filing a false affidavit, but that's pretty much all that, that's the only accountability that we have. So here we go. I was juror number 630 in the case of South Carolina versus Murdaugh. Towards the end of the trial, after President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorney, which I understood to mean that Mr. Murdaugh would lie when he testified. She also instructed the jury to watch him closely immediately before he testified, including look at his actions, look at his movements, which I understood to mean he was guilty. Immediately after he testified, the foreperson, juror 826, said Mr. Murdaugh was crying on cue. That, again, that specific language is very difficult here. The foreperson, juror 826, criticized the former foreperson, juror 589, for handling Mr. Murdaugh a box of tissues when he was crying on the stand while testifying about his murdered son. Although technically, I'm not sure. Let me pause for a minute here. I'm not sure how a juror would have had the ability to hand a testifying witness a box of tissues. So this to me seems like a courtroom control issue that the judge should have taken care of at the time. Yeah, it does seem odd, doesn't it? It does seem odd. I've never heard of that before. We make sure that in my jurisdiction, we have a complete separation between our jurors and our witnesses and the attorneys. Like they are just completely kept to the side, completely. So they don't have any piece of it because, you're not, yeah, they were sitting super close. Okay. Interesting though, isn't it? That would have even been possible. That seemed like that would have been an issue that the judge would have addressed at the time, but I don't know. All right. While testifying about his son, she told the jury, "We cannot interact with Mr. Murdaugh because that's what the defense wants us to do." The jury frequently discussed the case during breaks before deliberations, which is normal. Towards the end of the trial, Miss Hill came to the jury room a lot. That's normal. Miss Hill and the foreperson, 826, had a private conversation on multiple occasions. The foreperson, juror 826, would tell the bailiff that she needed to speak with Miss Hill. Miss Hill would arrive, and then she and the foreperson, juror 826, would go to another room to have private conversations. The conversations typically lasted 5 to 10 minutes. Now, I think them having conversations in and of themselves may not be the issue, but the appearance is pretty bad, though. To have the clerk of court talking with a foreperson, I think it's got an appearance of impropriety at a minimum. In my opinion, because that is kind of suspicious, I would think. Yeah, Ava, I agree. The foreperson, juror 826, never said anything about the content of the conversation. For example, she never communicated logistical information after those conversations. So the inference then is that she wasn't getting like technical information about what her job was as the foreperson. They shouldn't talk to jurors like that at all. Absolutely, Steffi. Yeah, it is suspicious. I agree. We're so careful with our jurors to make sure we don't say or do anything. In fact, during voir dire, one of the things that we always say is, just so you know, after we get started, I really don't want to have any negative effects, so I won't be talking to you. Please don't take offense. And we don't even look at our jurors sometimes, some of us. That's how I always was I just never even made eye contact with the jury. When we were in between breaks, if I wasn't doing an opening or a closing, it just didn't seem appropriate. This happened 2 or more times, more frequently towards the end of trial. When we began deliberations, Miss Hill told us that this shouldn't take us long and that if we deliberated past 11 p.m., we would be taken directly to a hotel. We had been driven from our homes that morning and were not prepared to stay overnight. Didn't anybody in the jury think this behavior was suspicious at the time and report it? Good question. I think, again, we've got this kind of small town situation where they're not really sure if that's something that's reportable because none of this information, of any of these affidavits, came out until they were asked by defense counsel. I agree. The ethics is definitely questionable. Yes, they do. It does sound from this side, from this one perspective we have here, it certainly seems like there could be some taint going on. Absolutely. Okay, so additionally, the smokers on the jury asked to be allowed to take smoke breaks, but were told they could not smoke until deliberations were complete. That's completely unreasonable. I had a question about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. That's a really important thing, although that happens a lot. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a television show. So there is our signed affidavit of juror number 630. That's our first exhibit. So on my jury, we judged which lawyer wore the better suit. True story, Chuck. I tell you, we got to be careful. We don't realize, I think, a lot of times what the jury notices and what they don't notice. Like, we're thinking we're putting on this great show, and meanwhile, they're like, why are you tapping your foot so much? Like, we didn't even think about it. We get a lot of training about that. Still seems fishy. Why is the defense attorney going to jurors' home to talk to them in the first place? Well, I think a big piece of that is because we've got, kind of this small town situation where like those jurors are not going to come in and go talk to, big city attorneys for a defense counsel. They're going to need to kind of be wooed into speaking up and seeing what's going on. You can see the name. Oh dear. That was a very good redaction. So here we go. Exhibit B. We've got another juror. Juror number 741. Watch the trial. He lied about lying. I think there's a lot of fabrication going on in this case. I think we've got lots of different elements. Seems too scripted to me. Okay, fair enough. Identity protected. We saw what happened. Yeah, true. All right, here we go. So we've got an affidavit here of Holly Miller. Here is her affidavit. So, these two and I met with juror 741. So now we've got, hold on, let's just make sure we read this right. Affidavit of H. Miller. So we have an affidavit of this person regarding this juror. So this is classic hearsay. In hearsay we have 27 exceptions, and I'm not sure the information of a juror telling you what happened would fit into any of the exceptions. That's clear hearsay. Paralegal. Yeah, that's, I'm not sure how much credibility we're going to want to put into this. I don't know. We'll see. Met with juror 741 in this case at her home. At the meeting, she indicated she would sign an affidavit. However, we were unable to arrange with her a suitable time and place. It seems like if something was this important, you would figure out a suitable time and place. So, during the meeting, relayed the following information to us. Again, this is all hearsay here. I'm not sure. Yeah, zero credibility? Sure. Yeah, I mean, it's a little suspicious, but, we'll see. It's not the only thing. They're going to want to put everything in it that they possibly could. During the trial, she witnessed the clerk of court come to the jury room, and Miss Hill, the foreperson, went into the bathroom. After Miss Hill and the foreperson exited the bathroom, Miss Hill told the jurors they could not ask the foreperson questions. Several times during the trial, Miss Hill told the jurors that the media would want to interview the jurors at the end of the trial. During one of those conversations, she passed out business cards from media to jurors. At the end of the trial, Miss Hill told the juror that no one from the media wanted to interview her. Oh, that's not very nice. She told this juror that no one wanted to interview her. Okay. Right before the defense put up their case, Miss Hill told the jurors, y'all are going to be hearing things that will throw you all off. Don't let this distract you or mislead you. All right, so that's a direct quote. But again, this is from the paralegal's perspective when they spoke with this juror. After Alex testified, 8 jurors indicated they did not believe his testimony. Recall juror 544, known as Boston, was very emotional during the trial. I would say so. Double homicide trials are tough. They're hard work. During the visit to Moselle, juror 826 and this other person walked to the scene together. Then 826 began walking with the clerk of court. There were many times that the jurors were not kept together, but were in 2 separate rooms. Noticed jurors talking about the case before deliberations began. Neither she nor juror 785 joined in on the conversations about Alex. As the jury was deliberating, she believes Judge Newman came to the room she was in and told her that the jury would have to spend the night at a hotel if they did not vote by a certain time, but she does not recall the time deadline. Okay, this is important, this distinction. So she's saying that she thought the judge told her that if they didn't come to a particular agreement that they would have to stay in a hotel. That's pretty significant. That's a big difference between the clerk of court and the judge explaining it. I think that gives us a different spin on things. So
Juror 741 was the first former juror to provide information that the clerk of court made statements to members of the jury about the evidence presented during the trial prior to jury deliberations. Ms. Hill's conduct was corroborated by other jurors during subsequent interviews. Now, again, this entire statement does not seem like it's exactly what this juror said here. It's a summary of who this was. First former juror to provide information that they made statements to members of the jury. I don't know, everybody. This one's a little hinky to me. This one's hinky. The affidavit of Miss Holly Miller regarding her discussions with juror 741. I'm not sure. None of the jurors who gave affidavits agree on the facts. That's kind of what we're looking at. Yeah, vague. Yeah, not great. That one's not great. Let's take a look here at Exhibit C. So, draft transcript of records excerpt from in-camera conference. So this was that chambers conference that we had. So I've already kind of gone through this. This is exactly what they had put into their motion. So I'm not going to reread this again. This is regarding that Facebook post, and it's word for word. They made it its own separate exhibit, I think, for easy reference. But we had the that question about the Facebook post and whether or not this person's put the post up and took it down. Yeah, the Saint post. It looks like there was some consumption going on here. We're talking about the devil. So yes, that's why it's fishy that his attorneys were going to the jury's home. Yeah. There's a lot involved here. Yeah, this whole Facebook situation, I'm not really sure how critical that is. Someone was intoxicated and maybe talking about the case. Like, I'm not sure about that. All right, so now we've got Exhibit D. So we have the book, Behind the Doors, excerpts. So Behind the Doors of Justice. So let's take a look at this book that this woman has published in this situation. I think there's another one coming up, but yeah, so far I'm with you. I don't think it's particularly strong. So let's take a look here. We'll start here. Valerie. Valerie is a national Wall Street Journal reporter who has covered the South for 18 years. A pool reporter sent to Moselle with pool photographer Andrew. October 2021, Valerie signed a book deal with a division. And so it happened. Oh my gosh, this is going to be good. Are we ready? And so it happened. My 55th birthday fell during the trial in the spring of 2023. My birthday is March 10th, and Valerie was born in late February. So it was decided to have a party for both of us at her Airbnb on the night of her birthday. She invited many of her colleagues who were covering the trial for the regional and national media outlets. There was food, birthday cake, and a lot of laughs, and a little truth serum in the form of liquid refreshments. As we were cleaning up after the party, a few of us were asked how we would vote at that point in the trial if we were members of the jury. Before answering, we pledged a cone of silence. We pledged a cone of silence, and for that reason, I cannot reveal the results of our straw jury poll. What I can say is that many of the party guests agreed with what ended up becoming the actual verdict of the trial. Wow, I'm really guessing what they actually decided then, based off of your pledge. Yikes! Okay, the devil from the post is the birthday party. Yes, the voice is back. I think it's appropriate here. Okay, next, the Today Show and Dateline. Sunday night, after Alex was sentenced, I accompanied 3 jurors from the trial to New York City. As I mentioned earlier, Craig and Savannah of the Today Show interviewed the 3 jurors during a 7-minute high-energy segment. High energy? That's fantastic. While we were all at the Today Show green room, we met and took photos with the country music star Dustin Lynch, who was also getting ready to appear on the program to sing one of his hit songs. Once the taping of the Today Show concluded, we were whisked away to an 850-foot-high skyscraper building, a driver in a black Chevy Tahoe, to a different studio near 30 Rock where Dateline tapes some of its segments. What stuck out to me was that one of the jurors mentioned to her producer that she had been craving for pizza and cheesecake, and the next thing we knew, both were delivered in time for lunch. This trip was extra special for me because it was my first time ever flying in an airplane. We flew from the Charleston to New York City and could order whatever we wanted. I chose pretzels and a Coke to relieve some of my anxiety. Then a black Chevy Tahoe car service was sent to pick us up from LaGuardia Airport. And we got to ride through one of those dark underwater tunnels that let us out in the city that never sleeps. NBC put us in the hands of the fabulous Haley Barber, Dateline producer, who put all of us up in a nice Manhattan hotel and fed us at a restaurant in the Avenue of America, a block away from 30 Rock in Midtown Manhattan, on the eve of the interviews. Afterwards, the juries told me that they felt like they were heard and loved their 15 minutes of fame in the Big Apple. The end. That's the end of tonight's reading. Because I can't go on anymore. It's too much. What do we think what I did during my summer vacation? Pee-wee's Big Day Out. Oh my goodness. Oh my goodness. That was rough. Yeah. So, yeah, I'm all right. Yeah. I'm not sure about this. I'm just not sure. Where's Fabio? Yeah, they were starstruck. All right, so let's just... All right, there's more. I'm not going to be able to make it through all of this, but this part I do want to talk a little bit about because she's talking about what's happening in court. So I think this is important. We, the people, duty, honor, and service. Okay. So let's just go through a couple paragraphs of what she's writing about here. That's what, well, working with jurors is always a unique experience. And like with any jury, we had some behind the scenes happenings with our jurors, the alternates and the originals for the Murdaugh trial. While most of the jurors were focused and engaged during the Murdaugh trial, we did have one juror. Oh no. I think this is going to be troublesome. Who was an alternate at one point, who was not. Whoa, burn. That's a burn. She was more focused on the crowd who was watching, who was or wasn't following Judge Newman's rules, and so on. Whoa, we're getting the tea now. We're getting the tea. She caught a new visitor to the courtroom who was sitting directly across from her, who looked like she may have been taking a picture of the jury, and that wasn't going to fly with her. Another juror couldn't or wouldn't sit still during the trial, and it seemed like every time she shifted her chair, it made a loud squeak. Occasionally, attorneys would wait for the rhythm of the squeaks to subside before continuing their cross-examination. Then there was the egg lady juror. What? The egg lady? Oh no, I have concerns. All right, the juror worked on a monkey farm in Low Country, and she drove Judge Newman bananas one weekend, pun intended. Oh my gosh. Through the Facebook page, Walter Burrow, word of mouth, about 20,000 followers saw this juror's ex-husband post. Oh my gosh. No, the Facebook post is in the book. Here it is. Oh my gosh. About how she was talking way too much to friends and family about the case. Many people became aware of the situation after court on Friday, February 24th, and it was brought to the attention of Judge Newman. I typically didn't have the time or energy to watch any media coverage of the trial, but on that Friday night, I scrolled through the Walter Burrow word of mouth social media feed and saw the post from the ex-husband, but he didn't mention the juror's name or her juror number. Wow, the writing. I agree, Suze. Oh, yikes. At the time, I didn't think anything of it. Kept scrolling mainly because I had been inundated with emails and messages from people all over the world about what they had heard, what they had seen, how the prosecution and defense should run their cases, how Judge Newman should rule, what to address with anyone and everyone involved in the courthouse. This is the Law and Order episode. Oh my goodness. It's a lot. It's a lot. And so on. I felt like a principal dealing with tattletales and problems and issues every day. It was tiring. When Monday morning came, Judge Newman asked me to find the social media post. One of our techs in the clerk's office, Lori Weiss, whoa, names. Wow, changed the names to protect the innocent. Looked and couldn't find it at first. Luckily, though, she kept looking, and we saw where the post was taken down and replaced with an apology from the juror's ex-husband. He said Satan had gotten a hold of him, and he had been drinking at the time he posted and was now very sorry. After Judge Newman interviewed the juror and corroborating witnesses about the situation, he removed the juror from the jury before court started that Monday morning. We learned later from the ex-spouses hadn't seen each other in 14 years, and the former juror had 3 restraining orders against her ex-husband. Wow, this information shouldn't be made public. This is a lot. This doesn't seem quite right. Yeah, I agree. Did she self-publish? I think so. I think it was self-published. I have concerns here. Yeah, mind your business, Satan. Oh my gosh. Oh my goodness gracious. It's a bad dream. Yeah. Tattletailer. I know. Oh my goodness gracious. Oh, I shouldn't laugh. This is awful. It's just so awful. Oh my gosh. Oh my goodness gracious. She likes eggs. She paid $30,000 up front to publish? Oh my goodness. Oh my goodness. That's awful. The burn book. Oh my gosh. Days of Our Lives. I know. It's really got that feel to it. Okay. I'm not going to be able to read through the rest of it. But she goes on and continues to incriminate herself. Oh, she's got a co-author. All right. Let's see. Let's just double check. We got to make sure we have our citations in here properly. Okay. Rebecca Becky Hill with Neil R. Gordon. Oh, and here, clerk of court. And is this signed? Is this a signed copy? I don't know. I don't know what's going on. Really, a former news anchor. Oh my gosh. Oh my gosh. Fire Neil. Oh my gosh. You guys are hilarious. Oh, she was apparently selling signed deluxe copies. Okay, I was wondering because it looks like she signed it. And her name, Becky, is in quotes here. So, new trial. I know. Oh, my gosh. 8th grade fan fiction. Oh, my gosh. Just signed by Satan. All right. Okay, I got to pull myself together. This is her cousin. Really? Oh, my gosh. She wants to go back to New York City. Oh my goodness. Okay. Exhibit E. Now, I will be straight with you. I printed this out and it is just completely not readable. So I'll just kind of show it here that we do have it. But honestly, it really wasn't anything different than what they already put in the summary here with an ugly post that I've deleted and towards a certain person. Broke down, started drinking, I was drunk, blah, blah, blah. I'm sorry. So again, this is just, I guess, copies of the Facebook posts in here. So here's the Bible, God, featuring church. I think the devil's in here. Satan is in here. So I can't really, I can't read it. It just didn't come out that clear. But, I think it's an accurate showing of what they summarized in the brief with the ethics sneer. Please. The devil waters tequila. I think you're right. I think you got. Yeah, I think so. I mean, if you can pull this petition up. Oh, I hope the background sound is okay, everybody. I'm so sorry. Of course, the person next to me is mowing right now, so I hope it's not too bad. But Yeah, this is exactly how it printed out. So I have a very, very robust printer with excellent ink. So it's not me. I'm just going to say that. Oh, okay, good. I'm glad. I'm pretty careful about that. But all right, so now we've got Exhibit F. This is the affidavit from Tim Stone. So this is the person allegedly who was involved in the Facebook post. Okay, excellent. What in God's name is this? We're all asking that question, really. It's a private account. We can't see his side. I know, I feel bad. She's been mentioned so many times. No, this book is the book that Becky wrote regarding her job as the clerk of court during the Murdaugh trial. The bad husband. All right, so here we go. Here's an affidavit. Again, this is a sworn statement. Number 1, I am the ex-husband of this juror. I did not post anything on the Facebook group. Why do we have an affidavit where he's saying he didn't do something? Oh my goodness. All right. I did not post anything to the group. I did not post anything on the social media page or on my own Facebook social media page about this person being a juror that was talking way too much to friends and family about the case, or that Satan had gotten a hold of me and I had been drinking at the time. I posted and was now very sorry. So his affidavit is saying it wasn't him, that he didn't do it. This is a sworn statement. Nor did I post what's attached in Exhibit A, which has been represented to me to be an alleged post by this Facebook group. All right, I did not have a Facebook page set up as Timothy Stone. It was Satan that posted it. Oh my gosh, I can't. Come on. Oh my gosh, is this for real? I can't. I don't know what's happening. I do not have a Facebook page set up as Timothy Stone. My profile name is Tim Stone, so vastly different from Timothy. I was never contacted by law enforcement. The South Carolina Attorney General's office. Oh, I believe you, Emily. I believe you. The clerk of court, Becky Hill, or anyone from the county clerk of court's office. Okay, I did not know that this person was on the jury until I heard her voice on a recording when she was being excused as a juror, and she was discussing something about eggs. Oh my gosh, the egg juror, it all makes sense now. I feel so good. So oh my gosh. Oh, I can't. We've come completely full circle. Okay, just one moment. Oh my goodness. I'm sorry, I'm coming. Okay. No, it's serious. This is serious business here. This is serious. Okay. Here we go. Too expensive. No, we did not. That did not happen. I did not just read that. Okay. I'm sorry. Okay, here we go. Oh my gosh. All right. I can't. Who just said Satan eggs hit different? Who said that?
myself together. I need a drink of water. I'll be right back. Okay. Okay, serious. It's a homicide case. Serious. Let's be serious. Walk it off. Okay. Okay. Oh my gosh. All right. Here we go. We're gonna keep the show going here. Let me keep it going. Sorry about that. Okay. All right. Number 6. Right. Flip the page. All right. That was it. That was the last comment. Okay. Whew. All right. Pull myself together here. Sorry about that. Sorry. Okay, here we go. All right, so what we have learned, let's make sure we know. What have we learned? Mr. Tim Stone did not write anything. Even the judge laughed at the eggs. Okay, so he didn't write anything. He didn't have anything to do with anything. He didn't talk to her. And all he knew was some kind of egg conversation. All right, excellent affidavit. Okay. Oh my gosh. All right, here we go. So now we have Timothy Stone's post, which we've gone through again. Right? Excuse me. So yes, we've got a post that Timothy Stone did not do. Continued on here, which again we can't fully read. Was it a full dozen? You guys are killing me here. Okay, whew. Moving on. Exhibit G, the affidavit of P. Barber. Here we go. This will be a sobering affidavit. I can tell. It'll be sobering. And it looks extensive, so here we go. Oh, I'm an attorney for the firm of this person and counsel of record for the defendant. Okay, so the defendant's counsel. Excellent. I met with Tim Stone at his home. He provided his Facebook login information, allowed me to download a copy of all of his Facebook activity. A true copy of the download is attached as Exhibit A. Thank goodness for that. The contents of the download speak for themselves because they say nothing. They say nothing. There's nothing involved. He didn't do anything. Oh, what a review of them shows. No post was made apologizing for a previous post. There are no posts whatsoever to the Facebook group. And Facebook's stated retention policy deletes posts after 30 days. So any post deleted would not be recoverable. Okay, so what have we learned? Tim Stone knows nothing. So I think that what they're saying here, they're saying that what the statement that she made in her book was false. And the statement she made to the judge was false. All right, so we have a credibility issue involving the clerk eggshell employment. Yeah, they could get the entire history, but I mean, how important really is this? We learned how to think about eggs. I just don't. This whole situation is ridiculous. All right. Here we go. Exhibit H. Oh, my goodness. All right, we've got that. So, P. Barber, Exhibit G, isn't particularly persuasive. They scrambled to get it together. It's not a yolk. Okay. Oh my gosh. All right, Exhibit H. Affidavit. Permanently deleted. That's true. Exactly. Okay. Juror number 785. Here we go.
I was juror 785. Okay, serious, double homicide, serious. During the presentation of the defense's case, after President's Day, but before Mr. Murdaugh testified in his own defense, Rebecca Hill told the jurors not to be fooled by the evidence presented. Okay. In late February, I just can't understand. I can't either. Miss Hill questioned me about a Facebook post. Are we still going on about the Facebook post? All right. It's like, okay. Facebook Watergate situation here. Okay. She summoned me, wow, that's harsh word there, to speak with her alone in an office in the courthouse. She told me someone emailed her about a post my ex-husband Tim Stone purportedly made, which purportedly, that's a lot of purportedlies, stated that I made comments to him about the guilt or innocence of Mr. Murdaugh. She directly asked me whether I was inclined to vote guilty or not guilty. I told her I had not made up my mind and that I wanted to hear all the evidence before deciding. Miss Hill said the post said I had been drinking with my ex-husband and that while with him, I expressed opinions on the guilt or innocence of Mr. Murdaugh. That never happened. I told Miss Hill it never happened. I did not go, quote, drinking with my ex-husband. In fact, I had not seen him for approximately 10 years. It does make you sound smart. I asked to see the post, but Miss Hill would not or could not show it to me. I have never seen it, and to my knowledge, no one has. This mysterious Facebook post is really something else here. Later that day, Miss Hill told me SLED and the county sheriff's office personnel went to my ex-husband's house, and he purportedly confirmed he made the post. She told me she would reinstate a restraining order I previously had against my ex-husband. Now, this is pretty incriminating right here. Okay, so this is the egg lady. It's just not right what's happening here. Okay. I don't know what is wrong with me. I'm sorry, but I just can't with the eggs. Oh my goodness. Okay. Oh, all right. Oh, I did not know about the apology post referencing until Miss Hill's book. You did not just send me eggs. Who sent the eggs? Oh my goodness. Oh my gosh, you people are just a stitch. So funny. Oh, I adore you. All right, here we go. No more eggs. All right. Here we go. We gotta talk about Satan again, okay? Here we go. Let's get back to it. If we don't do it, who's going to do it? Oh, all right. I did not know about the apology post referencing Satan until Mrs. Hill's book was published. I have since reviewed that post and can definitely state the post is not by my ex-husband. He does not go by Timothy. The profile picture is not him, and the phrasing of the post is not phrasing he would use. It appears to be a post by another person who happens to have the same name. That's so coincidental. What a coincidence. It does not appear to be a post to the Facebook page. It's all funny games until Satan and eggs.
Okay. When Miss Hill first asked me about the Facebook posting purportedly made by my ex-husband, I showed her a picture of my ex-husband. For that reason, I now believe she always knew the apology post referencing Satan was not posted by my ex-husband. Oh, on March 2nd, the day of the verdict, I received a call from my ex-husband, Tim Stone, as I was getting on the bus to travel with the rest of the jurors to the courthouse. I did not answer. The phone call upset me greatly, and I asked to speak with the clerk of court, which I did by telephone using bailiff Mr. Bill's phone. Thank goodness, Mr. Bill. I told her I was scared. And she said the Murdaughs probably got to him. Not Mr. Bill. Miss Hill then again asked me questions about my opinion regarding Mr. Murdaugh's guilt. She asked if I was leaning one way or the other. I told her that Creighton Water's closing was good, but I still had questions. This affidavit is ridiculous. Yes. She asked me what kind of questions, and I replied questions about these things. She asked what would make me think he's innocent. I stated that no murder weapon was found. She then asked, well, what makes you think he's guilty? I said Paul's video at the dog kennels. She then stated that everything Mr. Murdaugh has said has been lies and that I should forget about the guns. They were never seen again. Miss Hill then asked about the views of the rest of the jury. She told me if the foreperson would just go in and ask for a raise of hands, this would be over and done with. She said, everyone needs to be on the same page. She then again said she would reinstate a restraining order I previously had against my ex-husband, and that she would call Judge Newman about the restraining order. I then went to the jury room. Approximately 10 minutes later, I was excused from the jury. During the proceedings, I asked Judge Newman if he had spoken with the clerk of court. He only said, this is not because of your ex-husband. Ooh, that was his response. 2 weeks later, I did answer a call from my ex-husband. I angrily confronted him about the post he purportedly made because I knew I had not made the comments he claimed I made. He emphatically denied ever making such a Facebook post and genuinely seemed not to know what I was talking about. On one day during my jury service, approximately 1 or 2 weeks before the verdict, Juror 864 and Juror 826 were in this single toilet unisex bathroom together for an extended period. They were known to do so frequently to discuss the case. Juror 729 referenced it as A and D time. In the van going to the courthouse, Juror 864 said special Thank you kindly. Thank you for the present. I appreciate it. Special Agent David Owen lied on the stand, but that nothing would happen to him. Oh, dear. It's not that. Lying on the stand. I will not eat them in the house. I will not eat them with a mouse. I'm just completely, my brain, everybody, my brain is gone. Okay. Okay, when we visited the Moselle crime scene, Miss Hill and Juror 826 walked off together, avoiding other jurors in order to have a private conversation. I am going to make it through this affidavit. I'm going to do that. I own a rental property which is leased to 2 tenants, Webb and Dandridge. On Saturday, February 18th, I delivered a refrigerator to the property. Okay, I was removed from the jury on the day of the verdict because a co-worker of Miss Webb purportedly said, said I expressed an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator. Miss Webb then worked at Domino's Pizza in Walterboro, So the coworker would be some employee of Domino's Pizza. Oh my gosh, Domino's Pizza's involved. No, I do not know whether Miss Webb actually made any such statement at Domino's Pizza or whether a coworker actually heard any such statement. After I was dismissed from the jury, I spoke with Miss Webb and Mr. Dandridge, who both excitedly, strongly suggested to me that my husband that the affidavits the prosecution drafted for their signatures was not what they said to him. They told me Sled showed up at their home at 10 p.m. after they were asleep, removed them from their home, put them in separate cars, and questioned them. Mr. Dandridge, did I just see pizza and egg emojis? Did I just see that? Oh my gosh. Oh my goodness. All right. And he told them I did not say anything about Mr. Murdaugh's guilt or innocence. Sled returned 30 minutes later. Who's Sled? Does anyone know who Sled is? Tara, I see you. I'm wondering who Sled is. I'm just going to put that out there. Again, woke them from their beds to serve subpoenas on them to appear in court the next day. Satan's Pizza Eggs. They arrived at the courthouse around 9 a.m. the next morning and were held for 9 hours until 6 p.m. when Sled. Okay, law enforcement. All right. I thought this was a person. I'm like, I thought it was a Southern thing. Like, that's a cool Southern name. Mr. Sled. I'm struggling. Okay. Yeah, I really did. I thought it was like, wow, I didn't want to seem ignorant of the ways of the South. Officers or prosecutor finally presented typed affidavits to them, saying they were their statements from the previous night that had been recorded by dash cams in the patrol cars. They said they signed the affidavits without reading them. Who does that? Who signs an affidavit without reading it? As I previously testified, I never discussed the merits of the Murdaugh case with Miss Webb, Mr. Dandridge, or any other person present, nor did I express an opinion on Mr. Murdaugh's guilt or innocence while delivering the refrigerator. Okay, that's a key piece here. Or during any other interaction within them during the trial. All right, we made it. He slays. Mr. Sled slays. He does. I can see that. Did someone say the egg division? Oh my gosh, everybody. Oh my goodness. They needed the refrigerator for the eggs. Oh my gosh. Yeah, okay, here we go. We made it. Let's keep on keeping on here. We're going to do this. All right, records from the excerpt of the in-camera conference. So this is the Chambers conference. Oh my gosh. All right. So let's just take a peek at what we've got here. All right. Okay. Have you put anything on Facebook? Oh my goodness. Why? Why are we back to Facebook again? Not regarding the case. I put a positive post on. I gave Miss Becky my full access to my Facebook. I've put positive posts on. I've done that for the past 3 years. But has anyone posted anything on Facebook about you? And I wasn't aware of it until Miss Becky told me today. What did she tell me? What did she tell me? This is a court. She asked me if I had an ex-husband, and I said yeah. And she asked me if I had talked to him about the case or being on jury duty, and I said no. And I questioned her why she was asking me that. I haven't seen my ex-husband since 2014. Does he live in the area? He does. He lives in Cottageville. Okay. And I have 3 restraining orders against him. Warning. So he's basically up to no good? I wouldn't say that. I'd say a lot worse. But that's a nice way to put it. Okay.
But she told me that. I was very upset after she told me that. I have, like I said, I have 3 restraining orders against him. I wouldn't have anything to do with him if I didn't have a child with him. But I haven't seen him since 2014 when we got a divorce. I have talked with him within the last year because I got a call at work that my son was in jail and needed a ride home. Oh no, her son. Oh, I feel bad. I feel bad for her son. And I did call his father and ask him to go get him, which he did not do. But other than that, I have not seen him, talked to him, or anything else since 2014, other than getting restraining orders in Colton County, one in Orangeburg County, and I have one in Berkeley County. Oh my goodness. Oh, this woman. Oh, I feel bad for her. Okay, the court. Wow. But Miss Becky said she went to look for the post again and that it had been deleted. And I don't know who she talked to or anything else, but she said apparently, when did she tell you that? It was after you let us go on that last break. I was very upset and she came down and talked to me and said that apparently I don't know who talked to him, but said he was drunk and removed the post. So has she discussed the case with any of the jurors? Has the clerk discussed anything about the case with anyone on that jury? Not that I'm aware of. Okay, she was just discussing with, sorry everybody. That's my bad. There we go. She pulled me aside, and when we went downstairs after the last break, I want to say it was after lunch, and we came back, and that's when she first told me about it. And then when we went back into court, I was kind of screening the audience to make sure that my ex wasn't out there. And she came downstairs after the break and told me she had found out that he was drunk and had made a drunk post. And I don't know what happened from there. I have no clue. And you work at I work at a monkey farm. No. I'm sorry. Oh my gosh, we're at a monkey farm. Oh my god, I can't. Oh, all right. This can't be real. Is it real? I'm sorry, I'm trying. All right. I'm sorry, I apologize. All right. I apologize. That was unprofessional. Hold on. All right. All right. Okay, just one moment. I can't. Okay. Serious, here we go. Sorry about that, everybody. Okay. All right. Monkey Farm, right? We were at Monkey Farm. All right. Okay. I work at a monkey farm. Monkey Farm? What did you do there? I work in the lab. For the lab. All I do is watch monkeys. Okay, all I do is watch monkeys. It's a testing facility. All right, let's get serious. There's monkeys involved. Serious monkeys. Where they try and come up with cures for like AIDS and cancers and leukemia. That's a respectable job. That's a fantastic job.
Yeah, good thing I'm not in court. Absolutely. Oh my God. I would ask for a recess at this point. I really would. Okay. You're happy to be here away from the monkeys for a while? Yes, I miss my monkeys. Are they pretty smart, as everyone says? They're very intelligent, and they hurt and bleed. They have feelings, just like you or I do. That's They do. Okay. That's a moment. All right, that's a moment. That's understandable. Have a good night. Thank you. Okay. They're going to bring me back to my car, right? They didn't leave you, did they? Yes. Oh, they did? I'll go and get her to the bailiff, and they'll go get her. I'll go down there to a bailiff. They left, and make sure they get her home. Y'all have a good night. Okay, bye. Juror 785 exited the room. Well, I got a name now. A name. Clifford Dandridge, B Street. Oh boy, I'm not too pleased about the clerk interrogating a jury, as opposed to coming to me and bringing it to me. I was surprised to hear that. Yeah. So, dun dun dun. All right. Hold on. Let's make sure we've got everything here. And we do. So here we go. Clifford the Big Red Dog. There's just so many elements to this. So many key pieces. It's really, it's got lots of layers. Now, let's move on. Jury 326. I'm so lost. I'm lost too. I really am lost. All right, Exhibit J. Let's go into another juror here. Now, we again have Miss Holly Miller. She's the one that spoke with the juror and is now writing down what the juror told her. So this is what we would clearly call hearsay, and I have no idea if any exception would be appropriate whatsoever. So, these two fellas and I met with juror 326 in the case of South Carolina versus Murdaugh and his mother at her home. All right, so the juror was with his mother. During the meeting, juror 326 relayed the following information to us. Juror 326 was asked if Miss Hill told the jurors not to let the defense mislead them. He did not specifically recall the statement, but he did recall Miss Hill commented to him and other jurors about the photos that would be admitted into evidence, indicating that the images would be disturbing. Okay. Juror 326 also stated that the jurors were stationed in two separate rooms when they were not in the courtroom, and that he was in a room with mostly other male jurors. He was not in the same room as jurors 630, 741, 785. Juror 326 stated that Miss Hill would visit the other room more often, and he could not hear what she was telling the jurors in the other room. During the trial, Juror 326 and others discussed the case prior to deliberations. He did not discuss the case with anyone outside of the jurors. He further commented that some of the jurors were going into their office because of financial reasons, and that the people were talking to coworkers because coworkers wanted info. Before deliberations began, Juror 326 indicated that minor conversation led him to know who was yes and who was no. His vote changed with new evidence. Okay. As the jury was deliberating, the bailiff and Miss Hill told the jurors that they could not take a smoke break during deliberations. There were 6 smokers on the jury. After the trial concluded, a group chat was formed with the jurors, but Juror 326 dropped off of the group chat because there were too many chats. When asked if he thought the clerk of court, Becky Hill, was inserting herself in the process of the trial, Juror 326 responded, "I can see this." And that's the end of Miss Miller's recounting of this juror's decision or statement. All right. So, Exhibit K. We're coming down. We've turned a corner, everybody. We've turned a corner. We're down to the last piece. I miss my monkeys. I can understand. If I was there, I would feel that way also. So, all right. Here we go. Grand finale. It's time for the grand finale. The last exhibit, Exhibit K. We're going to make it. She was exhausted. Yeah, I think we all are exhausted at this point. Oh, goodness. All right. Exhibit K, memorandum from Rebecca Hill. This is it. This is going to be the most important one. To DreamWorks. All right. To DreamWorks, aka Texas Crew Productions, from Rebecca Hill, Colton County Clerk of Court, regarding addendum to Texas Crew Productions. Okay, so this is it. This is the addition that was added. Dear so-and-so, I'm looking forward to your upcoming docuseries on the Murdaugh case, and I hope you'll be able to use some of my interview should you choose to. Because I am elected official, we need to modify 3 clauses in the location agreement you presented me, as it relates to my authority. Okay, Becky, okay. I'm not going to laugh. We're going to get through this. This is the most important affidavit. Please change the word owner to Colton County in every reference in the agreement. 3 dates and location fee. Low Country Story LLC agrees to pay Colton County Treasury a fee of $1,000 per day for use of the Colton County Courthouse facility, so long as it does not supersede any court proceedings. Payment will be made by the close of production. 10. Miscellaneous. Colton County, South Carolina can only enter into a legal agreement for services if it's to be governed here in South Carolina, not New York. As an elected official, I have no authority outside of the state of South Carolina. What is this? This is ridiculous. Yes, this is the Confederate Day rental. Yes. She's stating that your jurisdiction is not New York, it's in South Carolina, because that's where her jurisdiction is. Oh my goodness. Sincerely, Rebecca Hill. Now, we've added on this piece here. Let's see if I can decipher the cursive writing. We'll see. I haven't used this language in a long time. We'll see. Also, in exchange for the use of the likeness of Rebecca Hill in an interview on of a minimum of 0.05 second video and audio clip will accompany the usage of the first reference. The book cover for the book Behind the Doors of Justice, the Murdaugh murder, will be shown, and audio will include Becky's introduction as Clerk of Courts for Colton County and author of the book. Wow, that is a lot. That's more than what was needed there. Okay, so that's the end of that last exhibit. We made it, everybody. We made it. That's Exhibit K. That's it. We made it. I'm proud of all of us. We did it. I thought I was on Sesame Street. It was a close call. Yeah, this is questionable. This is hinky. I agree. Hinkiness. All right, so we've got proof of service here, which is normal. So let's boop boop. I survived. Oh, you all were trying hard. I think it was the monkeys that kicked me over. Oh, over the top. Okay. So here we go. We've got the motion to suspend the appeal and file the motion for a new trial. Okay, everybody, what do we think? What do we think about this? Do we have grounds? Do we have grounds for a new trial? Have we met the burden here? Have we, did our clerk of court in this situation tamper with the jury? What do we think? We've looked at all of the evidence. I think so. I miss my monkeys. Yes, I miss the monkeys too. No, okay, absolutely, yes. After laughing, I think so. Definitely a mistrial. Clerk will be gone. Okay, boop, boop, Greg. She really messed up. Okay, so do you think the affidavits are trustworthy? Are they credible?
We had multiple affidavits. They did say some different things, but yeah, I mean, it was 6 weeks of trial. It was a lot. It was a lot. They're scrambled. Yes, new trial, jury tampering, a lot of hearsay. Yeah, Barbie, I agree. It really is a lot of hearsay. It seems like all of the affidavits had some element of hearsay, and especially the ones where it was the defendant's attorneys' paralegals that were summarizing what some of the jurors were saying. Meeting with the foreman in the bathroom is enough. Okay. Holly is not a good witness. I agree. And don't trust SLED. Well, that's good to know. I don't know a new trial, but I do think further non-biased investigation. Okay, sure. And that's what they're asking for here. They're asking for an evidentiary hearing to go through and assess the credibility of the situation. Now, with everybody involved, the judge would be called in as a witness. Of course, the clerk would be. The jurors that wrote their affidavits would also be included to pose the jurors in question. I think that's a really big piece that defense counsel is trying to say as well, is they would have subpoena power to bring in the jurors and ask them questions to kind of hash it out, because they did not get everybody's statement. Does the clerk get fired for misconduct? It seems like she would, doesn't it? I mean, it is an elected position. That was a wild ride. That ride was more than I had thought we would have. Extremely prejudicial, yes. And we know the legal standard here is that it was not a harmless error. So we don't have harmless content that she was saying to the jurors. I heard she hasn't yet. Yes. Okay. My goodness, I'll need to read this and get... Oh my gosh, it's a lot. Yeah, Miss Becky, bye-bye. I'm not sure. It's a good question. Is what she did criminal? I'm not sure. I mean, jury tampering does have any kind of influence on a witness, and influencing on a juror can absolutely be charged. I'm not sure how they charge it here. Can we see the law on South Carolina County court clerks? Yeah, I don't have it with me, surprisingly. I didn't think I would need to pull it. But yes, I think that that's the key, is to look and see. Do you think they will be holding testimony back? That's a great question, Greg. I think we have those elements of this being a small community. I think that was one of the problems, getting everyone to come in the beginning to even go through it. I think that'll be definitely a huge problem. She has to be held accountable if she deliberately did it. I agree. She tampered by saying they would have to stay overnight. That's also true. I think, again, that's well beyond her scope of duties. Is it unusual to separate the jurors like that? Squee, I found that to be a little unusual. And, from what I've read here and the research I did, it looks like they were separated into one room with the males and one room with the females, which is very weird. But then I didn't know about Confederate Day, so I'm not sure what's going on there in the South. I'm not sure. I don't know if they do that or not, if that's like their protocol. The book takes it to another level. I agree. I completely agree. Definitely wouldn't have any more juror contact. Absolutely, Locke, at a minimum. Yep, boop, boop. And no smoke break. Yeah, I'm really concerned about that also, because, of course, we try to treat our jurors with the most respect that we can and to make sure that they're comfortable. I mean, it's hard being a juror, especially a 6-week trial. I mean, and this trial was hardcore for anyone who watched it. She incriminated herself in the book. I agree. Clerk rushed jurors for her book sales. And I think you're right. I think that's one of the biggest pieces the defense is trying to say here. Imprinted on the jury. Yeah, which is not okay, unfair. I think you might be right too. I think she, even just if we don't take everything that the affidavit said completely true, they all seem to have kind of this overview of her position of what was going on. No motive needed. Okay. A juror can be held in contempt of court. True. She wrote the book in 2 months. Yeah. This had as much drama as the Kardashians. It has everything, doesn't it? We have a book. We have the egg lady. We have the ex-husband. We have the restraining orders. We have 2 people with the same name. It has everything. 48 Hours did a piece on this. Really, really. I'll have to take a look at that. The birthday part, yeah. The pizza, oh my gosh, the Domino's. Delivering the refrigerator, it has everything. Kardashian's father knows best. Ouch, harsh burn, but accurate. I watched it all on TV. Yeah. I have seen a lot of clips from it. I didn't watch it in real time. She was writing the book in shorthand during the trial. Ooh. Do you think then that adds to her motive for talking with the jurors inappropriately? Because was that the key motive? She was trying to get her book done. She was trying to get the trial done so she could present this book and get it published. Is that the motive? Quid pro quo. Okay. Conflict of interest, 100%. She wanted fame. Okay. Writing the book on payroll time. Ooh, that's a really good point. That's an excellent point. So this is we're going through the motion for a new trial for the Murdaugh case, where we've got the clerk of court doing some questionable activity. Not if she paid $30,000 to publish it. Oh, that's another good point. Oh, the twists and turns. She knew better. And I think that's really a piece of it too, isn't it? She should have known better. Why the urgency, though? That's a good question also. They had been 6 weeks into a jury trial. What's a few more days? Bless her heart. Yes. Now that Southern phrase I am familiar with. Everyone's sure he'll get a new trial. I'm not sure if he will or not. It's anyone's guess, but it seems based off of what we've heard and based off of the fact that the state has to show that the contact she had with the jurors was harmless. That's their burden. And can they meet their burden? If not, then they will go to an evidentiary hearing. She had to make up for that $10 a day. True. Yes. Oh, yes. These are my homicide nails. Since we're going through a double homicide tonight. What if she was paid off to throw the trial? Oh, whoa, no. Really? Donuts? Yes. Oh my gosh, it could be though, couldn't it? We don't know. Was she involved somehow with them? Whoa. That's a great point. That's a really good question. Yeah, there's a lot of questions about the family with him. That would make sense, wouldn't it? Whoa. Wow. Mind blown. I'm creeped out that she found the juror's ex who had, oh my gosh. I agree, Cece. I agree with you on that. She was definitely involved in some hinky business, and we spent a lot of time on that Facebook shenanigans. A lot of time. They will have to move the trial. I agree, Greg. I think you're right. I think we're going to have a venue issue. She was Facebook stalking. Ooh, that could be. She blew the trial on purpose. Well, that's what, that's a kind of a good point. Too much time. Yeah. Whoa. This is crazy. This is really taking on another level. This isn't just about eggs and monkeys anymore, people. This is about a background, a family of that. My mother's a master at Facebook stalking. She goes straight for that friends list. Professional. I love to hear it. I'm not mad about that. Where did Becky get the $30,000 to publish the book? Oh, Daisy, next level. Yes. Oh my gosh. Good point. Yes, maybe. There was a lot of money here. There was a lot of money involved in this situation. Bex got checks. Domino's pizza with all the toppings. Yes, she could be a relative. Ooh, she could. She could somehow be related. I think because we're dealing with such a small town and such an influential case, I think we definitely can ask those questions. The evidence all point to Murdaugh. It's a shame she messed it up. I agree, Lisa. That at the end of the day is really it, isn't it? Because no matter who the defendant is, no matter who they are, every defendant deserves due process and a fair trial. And, if this comes out to be true, that what she was doing was true, I mean, there's no way for him to have gotten a fair trial. Now, you go through another 6-week trial, all those witnesses, all those people going through all of that again. I mean, it's awful. It's absolutely awful. But, again, it's not right to that fair trial. A lot of this is hearsay. I think that's a huge issue. I think hearsay is absolutely a huge issue with these affidavits. It seems like one piece alone isn't really the, smoking gun situation. I'm trying to watch my language here. So I don't think any one exhibit would do it, but I think a combination of lots of different pieces could definitely, kind of force the state's hand in meeting their burden. No way he'll testify. He's horrible on the stand. V, that's a good point. I'm always shocked when defendants testify. It is a unicorn moment when a defendant testifies and it does not come back and hurt their case. It's a unicorn moment. Truly. I truly believe that. The smoking pew pew. Thank you. I wasn't sure. So it's a good question. It didn't seem to really help him in the first trial. And if he was to get a second trial, they would know kind of where those weak links were. Didn't his son just do an interview? He did, Jen. Yeah, he did just recently do an interview, which was another question too. Like when this petition was filed, this motion was filed, was right around that same time as him as well. And I think Alex himself got into some trouble. I thought I had read somewhere that he had lost like iPad privileges in prison because he had, or jail, I can't remember where he's at exactly because he's on appeal, but he had lost privileges because he had been communicating with someone. He'd been doing an interview and had violated the rules. Okay. The son had an interview show coming out. Okay, right. He's a lawyer, so he thought he could talk his way out of it. Oh, Lisa, good point. What if Murdaugh had someone tell Becky about the made-up Facebook post? Ooh, Cece, another layer. Who will have to pay for this? Well, I mean, yeah, the state. Aren't her campaign financiers? Yes, they are. That's a good point. Great live. Oh, thanks, Scooter. Yeah, take care. Thanks for coming by. Always good to see you. I love to see you when you come and visit. I appreciate that. Have a fabulous night. His lawyer, but used another prison. Oh, okay. Yeah, interesting. Good night. Sleep tight. Don't let the monkeys by. Oh, my goodness gracious. Oh, my gosh. Do we know when appellate court will make its decision? No, I don't know. I do not know at this point. And I'm not sure which judge is going to hear it either. Now we are just smacking eggs against the wall to see what sticks. Well, yeah. Could his attorneys argue she had something to gain if he was found guilty? Absolutely. And I kind of get that feeling, Quinn, in this motion that they're trying to say she had, a motive to kind of move this along, to get those jurors to come in and to find him guilty. So she had this motive to keep it going. How long have I been practicing? A long time, Atticus. A long time. Actually, September today, I remember I was going to share my September 11th story, but I was on my way. I was driving to law school when I heard about it. And when we got to law school, all of us, kind of all professors, the deans, all the law students, we all came together into one room and were watching the towers going down. And I remember that, just a pivotal moment in my career. So that gives you some idea of how long I've been in the field. That was a tough day. That was a very tough day for everybody. Doc production as a legal intern. Yeah. It was tough. Oh, Sears Tower. Yeah, I think, everybody kind of remembers that key moment. And, like when the first bombs were dropped, and we had all kinds of moments like that. Thank you for your lives. Oh, Megan, of course, my pleasure. I'm glad we could talk about this tonight. For sure. Oh my gosh. Oh, wow. They gave them 10 days. Okay. I was supposed to be in the towers. Oh, Suze. Oh my gosh. You just moved to New York? whoa, should they settle instead of going back to trial? No, I don't think any kind of a plea would work out in this situation. I really don't. I think he is in a situation where he's like, the worst thing that could possibly happen has happened. Let's do it again. I was in law school for automotive. Oh, okay. I was in school for automotive where I graduated. Yeah, yeah. I mean, it was tough. Just months before that day. Yikes. You made my life laughing. Oh, thanks. Sorry about that. Sorry. I think oh, sometimes I just can't. It's just too much fun. It's 26, teaching in Brooklyn, pregnant with my daughter. View of the tower. Oh, yeah. Yeah, that day, you remember it forever. He's already in prison for life. He won't admit guilt. Suze, that's the key. And he's also got federal charges for money cases. Lots of different cases that where he's being charged with fraud. So he's definitely, no matter what happens, he's going to be in prison. It's just a matter of how long and which prison. My late dad was in the tower. Oh no, my gosh. No way did a building fall down. I thought it wasn't real. It was the third day of your honeymoon. It was so weird because the night before there had been like a mini series back when people watched television, and the mini series was about an airport and a plane had flown into the tower. And so I had truly believed the airport tower. I thought that people were doing some kind of hoax, like a publicity for the miniseries that had been on the night before. I really did. And then when I got to my law school, I was like, oh my gosh, how could this be? He wants his son to get whatever he has. Yeah, well, I think the little things are important. I think we've gotta have that. My kids were 1 and 3, driving over a bridge to the highway to go. Heard on the radio, got to the ER. Oh no, my gosh. Traveling, had trouble getting home. Oh my gosh. Did the clerk of court mess up big time here? I think so. I think she did. I think she messed up. My sister's professor and her family. Oh my gosh, I'm so sorry. Oh, that day. Oh, the Pentagon. Oh, yeah, it was a tough day. It was so surreal for those of us that were in a situation where we could kind of remember the moments. It was just, it's almost indescribable. They were just trying to get him out of state prison, want him in a comfy federal prison. Oh, Megan, good point. Everybody would prefer federal. Absolutely. Absolutely. Where did I attend law school? I went to law school in the Central Time Zone. So going back, it was hard. Yeah, I agree. Had trouble getting to college. Flight and movers got canceled. There's a huge difference. Oh my gosh, absolutely, Lisa. Huge difference. Worked in college. Entire college was still. Yeah, it was like, we get a lot of tornadoes where I live. And one of the best descriptions was, there's a moment before a tornado comes through and when everything goes still and then the storm hits. And it felt that way. That whole day felt like the tornado was coming. It was awful. New York City, days before. Oh my gosh. Oh, heartbreaking. Pennsylvania. Out of Cleveland. Oh my gosh. Oh, everybody. Oh, well, we survived, everyone. We made it somehow. Yeah, we made it somehow through it. The calm before the storm. Absolutely. I mean, it really was. It just hair raising. It really was. Oh my gosh. I bet your mom was like, oh my goodness. Oh, I can't imagine. We knew something was very wrong. Yeah, I think, when the first tower went down, we were all horrified. But then when the second tower went down, there was such a race to clear the second tower. And when it went down, we just, it was just awful. United our country. I agree. We were united. And I remember, President Bush coming on and being so clear about not blaming it on a particular religion or group of people. And I just remember that moment thinking, wow, this is the moment. To see the kids do videos saying a hoax. Oh, I know, Lonnie. Oh my gosh, I know. Aftermath was even more horrific. I know. Family member could not talk about it. Finally caught up with him. Oh my gosh, I know. It was a bad one. It was. I mean, it's almost indescribable. Oklahoma Tax Commission for training. Everyone was just quiet and shocked. I mean, Amber, there's just nothing that we can compare it to. Absolutely. The second plane hit. Oh, I know. It was just, yeah, it was tough.
Now look at us now. I know, Greg. I know. Those moments of unity, they are long ago. Huge collective trauma. I agree. And I think to some degree the trauma of the losses that we sustained during COVID are a bit like that. Just the losses, but the togetherness we never got. We never were able to come together like that again, which is just, yeah, it was difficult. Oh my gosh, Brittany. Oh, that's tough. That's tough. Yeah, it was a hard situation. Yeah, I agree. Those were tough days, Suze. We really, we kind of kept our eyes out on everyone the best that we could, in the best ways that we could. Lights are on tonight. Can see them from my window. Oh, my heart goes out. Oh, the toilet paper shortage. Interesting what we found to be the most important things. I myself, when everything started closing for COVID, I went to the store, and maybe this was because I grew up so poor, but I got like ketchup and peanut butter and water. Like the last thing on my mind was toilet paper. I was like, we need food, we need protein and dehydrated stuff, and oh, bidets. Yes. Oh, I love that. I love that. Eventual political. Yes. I think you have a good point, Matthew. I think so. Yeah, beans and rice, Brittany. Exactly. I never, I still to this day, I'm like, what were you after again? It was such a difference between, I think, those who really truly have never had anything, what we were going for. So mad at people for the toilet paper thing. I think that's fair enough. Nutty bars, boxes and boxes. Oh, we love that. Oh, we love it. The bidet was the real winner in that situation. Okay, I'm going to say it. And I stand by that. I stand by. Bought all the frozen food. Yes. Well, you have to. I mean, it's survival at that point. Baby wipes. Yes. Kim, thank you for coming. Thank you so much. Yes, we're kind of in the Q&A moment where we're kind of wrapping up here, but I'm so thankful you could come here and visit us. Where's your fifth finger? Is that freaking you out? I'm so sorry about that. Some people say it never happened. I know, and I'm sure people feel that way about a lot of things, that people are saying didn't happen, that the rest of us are saying, how can you possibly believe that? She already had the TP. Oh, I love that. I love that. She was ready. Yes, thank you, Lisa. Thank you. Yes, I will be, just for those who are ready to kind of head out, I will be live streaming tomorrow on my Tube of You channel. And I will be specifically going through the grand jury findings. So that will be the topic for tomorrow. So hopefully you can join me on my Tube of You channel. I will love to see you all. Oh, I know. It's hard, Daisy. It's hard when we live through that. And I think of so many other people that have lived through events that people are forgetting. One of them, in my humble opinion, that personally affects me is the whole situation with desegregation and the impact that it really had. I think that that's something that if you don't have someone that went through that in your world, you can't really understand it. 6:00 Central Time. 6:00. Yep. 6:00. And I will be on my Tube of You channel. I will be live streaming there. It's really got a different feel to it, everybody. When I'm live streaming on YouTube, it's just so... Oh, it's pretty calm. But, Sheila, absolutely. I will be going through the grand jury, special grand jury findings. I'll also be going through the petition to have Fonnie Willis recused. So, and the order that came down from that. So I will be spending some time on that. You're my favorite. Thank you. Thank you. Oh, you're welcome. Thanks for coming by, Mrs. Michael Myers. I hope you have a wonderful night as well. And don't do anything that's not friendly. But wonderful to see everyone. Yes, good night. Good night. Yes, yes, I will have this up within the next 24 to 48 hours. I've got one more live in my queue from last week. So after that, I will have this one posted. So all of them will be up eventually, but over on my Tube of You channel for sure. Thank you. Oh, you're welcome, Deidre. Thanks for coming. Yes, Brittany. Yes, yes, absolutely. Oh, it's so good to see everybody. Oh, Suze. Yeah, it's a tough day. It's a tough day. That sounds great, Daisy. I will see you tomorrow on the Tube of You. Yes, good night, Alice. It's good to see you. Good to see everybody. Yes, it's the same as my the bears, the boop boops. Yes, it's the same as my tube of my tube of you is the same as my name here, so you can come and visit me over there. The live streaming will be up and going. Yes, absolutely. My dad was a product of 60s civil rights movement. Oh, love to hear that, Snappy Squid. There's so much respect for that time period. So much. Oh, yes, you're welcome. Yes, see you tomorrow, everyone. I think it's definitely kind of time to wind down a little bit here. Love your content. Appreciate you. Oh, thank you so much. I have noticed I do need a good chunk of time to kind of rest my voice. Because especially with all my laughing. So I want to make sure I've got voice for tomorrow. But thanks, everyone. Oh, yes, yes, yes. Host an excellent teacher. Oh, that's so kind of you to say. I think so too, Locke. I'm with you on that. I really have enjoyed my time over there. So I will be back here on TikTok on Thursday, of course. So we will be going through the 2025 project, talking about that. We will see how that goes. Oh my goodness. Oh my goodness. So that will be Thursday. We'll have lots of fun with that. Oh my goodness. The emojis are coming out. We love that. Oh, yes, yes. Wet the whistle. Exactly. What time tomorrow? 6 o'clock. 6 o'clock. So I will be on, we'll see. I'm not sure if Hawk's going to join me or not. I kind of sent the invitation, but he's got his world and stuff to do, but I did send out the invite to him, but we will do 2025 here on TikTok on Thursday. But Tuesday, tomorrow, I will be doing the grand jury, special grand jury information. So that will be on my Tube of You. Talk told us about you. Yes, he's a stitch. He cracks me up. Yes, 2025. We will go through that. We're going to crack it open. I've got the Articles of Confederation I'll go through too, which I think are the closest. Anything Wednesday. Wednesday, I'm so glad you asked, Jen. Wednesday, I'm set to go through the Colorado petition. Now, I have a couple of bits with that because I'll go through the 14th Amendment, Section 3, along with the Colorado petition, and then I've got a couple of extra pieces I'll be adding on to that. There was an amnesty act that was passed regarding Confederate soldiers, specifically regarding the 14th Amendment, Section 3. So I'll be kind of taking everyone through that as well. So, this isn't a waste. For me, this is absolutely just so much fun. I just have so much fun. 6 o'clock. Yeah, 6 o'clock. I'll probably keep 6 o'clock this week, but my YouTubes, I may bump to 7. We'll kind of see how things go. For how it works out for everybody, but 6 o'clock is really the best time for me. So that really works for my schedule. Excellent. Yes. Pleasant dreams to you as well. So yes, I've got, we'll do Tuesday, Wednesday on YouTube, and then I'll be back here on TikTok on Thursday. So should be pretty fun. Come and tune in and hang out with us again. But I should probably make my way and get myself a cup of tea. So many laughs tonight, everybody. Thank you so much for your time. It's always wonderful to spend time with everybody here. I'm so thankful. Yes, and wonderful sweet dreams to you too. Yes, I'm in the Central Time Zone. So nighty night, boop boop. Yep, you bet, Frank. Always good to see you. Love that. We'll be back tomorrow on my Tube of You. Yes, Elle, good night. Thank you, Daisy. Oh, always wonderful. Suze, take care of yourself, Suze. And April, boop. Good night. Thank you. You are welcome. I'm so glad to see you all. Yes, good night to you too, Tay. Love that. Robin, yes, we'll have a wonderful night, everybody. Mandy, Casey. Yes, yes, I will be up Tube of You tomorrow. Absolutely. Good night. Good night, Kitty. Yes. Oh, bye. Bye, everybody. It's always so good to see you all. So take care. Thanks for the laughs tonight. That was so much fun. This will be posted up on my Tube of You very soon. So we'll see you all tomorrow on my Tube of You. See you over there. Good night, Greg. Have a great night.